If recording has begun. I think, okay, the recording has begun, so we can go on.
Right. So a transfer is a deed, an instrument or statutory form which transfers the ownership of a freehold or a leasehold property, the title to which is always registered with the land registry. So transfer in a layman's language will mean the passing of land or a lease or a charge from one party to another, by an act of the parties themselves and not by operation of the law. And it always includes the instrument by which such passing is effected. So when you look at Section 2 of the Land Act and Section 2 of the Land Registration Act, that definition suffices. So transfers, includes a conveyance, an assignment, a transfer of land, a transfer of lease, or even other instrument used in the disposition of an interest in land by way of transfer. So when you look at Section 43 of the Land Act, it supports the statement. So how do you effect a transfer? So you could effect a transfer one by consideration, and this is always with or without gifts. Okay, you could also effect a transfer, in terms of an instrument in the prescribed form or form approved by the registrar. Okay, and registration of the transferee as the proprietor of the land, lease, or charge. So, transfer to take effect immediately and not on the happening of any event or fulfillment of any condition at any future time. So transfer will take effect at that instance. It doesn't have to rely on subsequent or futuristic, fulfillments of some obligations or sort. So that is the law against remote vesting of interest. I don't know if you guys have been taught about vesting orders. I don't know. So that is the law against remote vesting of interest and conditional transfers. So these are basically rules against perpetuities, accumulation, and conditional transfer. As we speak right now, the National Assembly, I think there's a bill in the National Assembly called the Trustees and Perpetuities Act or something. It's an amendment bill. I think it's in the committee of the whole stage. So it, basically will have in terms of transfer and water view. And then when you look at Section 44 of the Land Act, Section 40 and 41 of the LRA also support exactly what I've just talked about. So transfer instruments not only transfers, land, lease, charge, but may also create an interest, for example, a lease. So Section 2 of the Land Act, again, on the definition of a lease, you'll be able to understand this particular point quite clearly. So transfer instruments or documents include, one, we have the transfer itself, and we have assignment, we have conveyance, we have vesting order, we have assent, etc., etc. Okay, so can you hear me?
Yes, I can hear you, Levins.
Awesome. So transfer made by the proprietor, or you could call this person an asset owner to land, which is normally perhaps legal beneficial owner, a personal representative, or a trustee, or a chargee, or a lessee. So it is made, by the asset owner, save for where the chargee exercises statutory power of sale. In this case, the borrower's land interest, and rights are normally subrogated to the lender. Okay, so a transfer is effected, like I've told you, it is always effected through a prescribed form, or such a form as may be prescribed by the registrar. And at your free time or at your convenience, please look at Section 27, 37 of LRA and Section 43 of the Land Act. So what are the samples of of prescribed forms when it comes to transfer? There's Form LRA 33, which is normally a transfer instrument on freehold land. Okay, we have Form LRA 63, which is always a transfer instrument of a leasehold land. Okay, we have LRA 57, which is the transfer of charge charge to a bank to transfer an interest or charge. Then we have LRA 35, which is for transfer.
Naveen, you're so fast.
Oh, wow, sorry. Oh my goodness. Okay, where did I lost you?
LRA 33.
Oh, wow. Okay. So, LRA 33, I've talked about this being a transfer instrument for freehold land. Okay. LRA 33. And then we have LRA 63, which is a transfer instrument for leasehold land. Okay. Then we have LRA 57, which is for a transfer of charge to a bank. Okay, to transfer an interest or charge itself. Okay. And then we have LRA 35. LRA 35 is for transfer of undivided share. Okay. And then we have LRA 36. LRA 36 is for transfer of what we call joint interest. I hope we are together. Okay. So actual transfer is effected by registration. Actual transfer is effected by registration in the register of title of an instrument of transfer. Okay, this is normally what we term as recording of the instrument. So the interest or the rights in the property is passed on to the purchaser upon registration. Okay. Right. So perhaps a question will come in orals. Okay. A panel will ask you, analyze the procedure you will follow to transfer land to a purchaser. Or the other panel member will ask you, describe perhaps the various, parts of a transfer instrument. And you can't answer this particular question if you don't know how Form LRA 33 looks like. You're blank, okay? So transfers are always divided into two spheres. We have the voluntary transfer, and then we have the involuntary transfers, okay? So what are voluntary transfers? So through an act of the parties in sale of land, transactions, or gifts of land. This is basically the underlying, element of voluntary transfers. So there is a judge by the name of Justice Nyamwera on gifts inter vivos. I talked about the gifts inter vivos. No, the gift itself intestate succession some time back. So Justice Nyamwera on gift inter vivos, in the case of re-estate of the late Gideon Manthi Zioka. Manthi is M-A-N-T-H-I, Gideon Manthi Zioka, deceased, 2015 EK LR. He said, I'll quote him verbatim, he said, for gifts inter vivos, the requirements of the law are that the said gift, may be granted by deed, okay, an instrument in writing, or by delivery, by way of a declaration of trust by the donor or by way of resulting trust, or the presumption of gifts of land must be by way of registered transfer. Or if the land is not registered, it must be in writing or by a declaration of trust in writing. Gifts inter vivos must be complete for the same to be valid. End of quote. So the re-estate of late Gideon Manthi Zioka, Justice Nyamwera's pronouncements will help you understand what, this particular gift inter vivos in relation to the voluntary, transfers really mean. So in the voluntary transfers, the forms are presented for registration in triplicate. So it contains information on consideration, if any, and acknowledgement of receipt thereof. So perhaps the forms executed, underhand, in the presence of a trusting witness, and the attesting witness are always an advocate or a public officer, who knows actually the executing party, or who is identified by a credible witness or identified through, the standard identification documents, okay? On to the involuntary transfers. So in involuntary transfers, these are transfers by operation of law on death, insolvency, or otherwise. A question will come. I mean, the panel member wouldn't ask you during the oral exams to tell them just define what transmission is. They'll ask you, okay, fine. How do you effect an involuntary transfer? What do you understand by involuntary transfer? So the fact that you have operation of law on death, because transmission takes place when there is operation of the law upon the death, okay, of that particular, transfer role. So you're there panicking, and yet you have just a trap laid for you. So be careful not to get into that trap. So transmission itself is the passing of land, a lease, or a charge from one person to another by operation of law on death, insolvency, or even otherwise. And that's in accordance with Section 2 of the Land Act and Section 2 of the Land Registration Act. So transfers by operation of law may arise in a number of cases, okay? One way upon which transfers by operation of law may arise are: one, you have death. That's common sense, okay? You have two, court attachment and sale. Three, you have vesting order. And I'm still asking if you guys have been taught about vesting order. I don't know. Your fourth thing, you have bankruptcy or insolvency. The other thing, you have adverse possession. Or at times you have prescription. And a very common question in oral exams, what's the difference between
possession instead of just, oh my God.
Someone's talking? Right, so I was talking about adverse possession or prescription. So common questions in orals, what's the difference between adverse possession and prescriptions? And I think Noah, sent some information on those too. So please go through the thread in those subgroups. And then the other thing, you have compulsory acquisition, okay? So what is a court attachment and sale? You're asked during orals, what is a court attachment and sale vis-a-vis involuntary transfer? So a court attachment and sale is the sale of a judgment debtor at a public auction. And please, if you haven't downloaded the Auctioneers Act by now, please do. The Auctioneers Act and the Auctioneers Rules under the subsidiary legislations, please do that, okay? So court attachments and sale of a judgment debtor at a public auction. Then the auctioneer, now being court agent, will execute the memorandum of sale with the purchaser. So the sale proceeds, paid into court and eventually released to the judgment creditor. Now the purchaser applies to court for a vesting order, which is an order that vests ownership on the purchaser and authorizes the registrar to register the purchaser as the owner, okay? So the court may also direct that the registrar of the High Court, or the executive officer to execute the court documents in lieu of the vendor. But what you have to know, that which is quite important, is the judgment creditor, may register a prohibitory order against the property pending the completion of the process to void any dealings by the judgment debtor, which may actually defeat her or his or her interest in the particular property. And please see Order 22, Rule 48 of the CPR, okay? So the other type of involuntary transfer, you have transmission on bankruptcy. Okay, so here, the debtor commits an act of bankruptcy, and the debtor of the creditors, filed petition at the High Court of Kenya. Another way in which a question will come during oral exams, what are the ways or what matters could be filed through a petition? Okay, So winding up proceedings. That's one matter that is filed through a petition. So the debtor commits an act of bankruptcy, and the debtor of the creditors, file petition at the High Court of Kenya. So a court, makes what you call a receiving order, placing the property in the control of official receiver. So there's a difference between the vesting order and the receiving order. A question is asked during orals. Give two differences between a receiving order and a vesting order. And I think I've talked about them. If you're keen, perhaps it was home. So further order known as an adjudication order is made adjudging the debtor bankrupt and placing the property of the debtor adjudged bankrupt in the hands of the trustee in bankruptcy. So the trustee in bankruptcy makes an application to be registered as proprietor under Section 63 of the LRA using Form LRA 44. Please note that the trustee in bankruptcy makes an application to be registered as a proprietor under Section 63 of the LRA using Form LRA 44. Okay, so the application is accompanied, by a duly certified copy of a court order adjudging the proprietor bankrupt. The trustee in bankruptcy will transfer the property using Form LRA 45. So when you look at Section 52 of the Land Act and Section 63 of the Land Registration Act and Regulation 59 of the Land Registration Act, General Regulations of 2017 and Insolvency Act of 2015, will basically, highlight all this. And for those who will find a error, for the orals, this is his question. The procedure for trustee in bankruptcy, to transfer the property. He'll do that. For him, it is just procedural questions. Okay. And then the other type of involuntary transfer is transmission on liquidation. So here, the liquidator shall, upon appointment as a liquidator of a company, make an application to be noted on the register under Section 64 of LRA in Form LRA 46. So the application shall be supported by 1. You have a copy of the vesting order, duly certified by a court. 2. You have what you call a statutory declaration in Form LRA 47, confirming compliance with the requirements of the Companies Act of 2015. 3, you have copy of a resolution, and this normally applies to foreign companies, appointing the liquidator duly certified by a company secretary or a notary public. And then the transfer by the liquidator shall be in Form LRA 48. So refer to Section 53 of the Land Act and Section 64 of the Land Registration Act and Regulation 60 of the Legal Notice number 278 of 2017, which is basically the Land Registration General Regulations, okay? The other type of involuntary transfer, you have transmission on death of a joint tenant. And a question that will never miss in oral exams, what is the difference between joint tenancy and tenancy in common, and how could the two interrelate with each other? Common question, I won't lie. So the property passes to the surviving tenant under the doctrine of jus accrescendi. I know people have been complaining about me using Latin terms, but it's unavoidable. Okay, so the property passes to the surviving tenant under the doctrine of jus accrescendi. So the surviving joint proprietor, notifies the registrar the death of a joint tenant and makes an application for the removal of the deceased, from the register in Form LRA 38. And then the application itself shall be supported by the original death certificate and a certified copy of the death certificate. So the registrar, upon receipt of this particular notice, will do the following. 1, the registrar will note the death in the land register. 2, he will retain the certified copy of the death certificate. And 3, he will return the original death certificate to the person who lodged it, okay? So again, refer to Section 49 of the Land Act, refer to Section 60 of the Land Registration Act, I refer to Regulation 54 of the Legal Notice number 278 of 2017. The other type of involuntary transfer is transmission subject, to confirmation of grant of probate. So here, the transfer of an interest in land of a deceased proprietor shall, unless otherwise be provided by any written law, be registered upon confirmation of grant of letters of administration or grant of probate. Okay. So it takes different shapes or forms. One, you could be having a transfer to, to a personal representative. So a personal representative who wishes to be registered as an administrator or executor shall apply to be registered as such in Form LRA 39, okay? And then the application shall be supported by a copy of the grant of letters of administration or grant of probate duly certified by the court. So refer to Section 61, subsection 1 of the LRA and Section 50 of the Land Act and Regulation 52 of the Legal Notice 278 of 2017. And then the other form that, transmission subject to confirmation of grant or probate takes, you have transfers by personal representative. Remember the other one, it was transfer to, this one is transfer by, okay? So in transfer by personal representative, these are transfers by the personal representatives to perhaps beneficiaries or third parties, shall be in Form LRA 42 and LRA 43 respectively. So the said transfers shall be supported by one, the copy of the grant of letters of administration or grant of probate duly certified by the court. You have copy of certificate of confirmation of the grant of letters of administration or a grant of probate duly certified by the court. You have certificate of title or lease, as the case may be. You have the consent of the head lessor, which is always the government, where applicable. You have any other consent which may be required. You have identification documents. You have PIN certificate. You have passport-sized photos. You have any other document as may be required under law. And whenever you ask this question in oral exams, please, if you even forget all these other documents, just say any other document as may be required under law. That is a point, okay? So just don't say you don't know. Just say that any other document as may be required under law, because that's what the statutes provide for. And then refer to Regulation 56, 57, and 58 of Legal Notice 278 of 2017. Okay, so at your own convenience, please read Section 65, 66 of LRA and Regulations 62, 63, 64, and 65 of Legal Notice 278 of 2017, and describe the procedure followed to: one, register as a proprietor a person entitled to land pursuant to a court order. Two, register a trustee as a proprietor of land. Three, register dispositions in favor on trust incorporated under the Trustees Perpetual Succession Act. 4, transfer the land by a trustee. Okay, then so at your convenience, please just have a look at that. So the second last part of involuntary transfers, you have the adverse possession or prescription. So adverse possession is a situation, where a person takes possession of land and asserts their rights over that particular land, and the person having title to it omits or neglects to take action against such person in assertion of his title for a certain period. And in Kenya, in the Limitations of Actions Act, is always 12 years. Common question in oral exams. So Section 7 and 17 of the Limitations of Actions Act provide for that 12-year limitation period for the recovery of land. That's Section 32 of the Limitations of Actions.
Hi, sorry, can you please repeat what you just said about the common oral questions? I was writing down what you said before, so I didn't hear the questions you posed.
Right, where did I lose you?
Just now when you said potential oral questions, so the questions you posed just before that. The last two questions.
Last two questions on was it on the assignment or which one?
No, I'm trying to, when you were talking about the second last part of involuntary transfer.
Oh, okay, I got you. So I've said a common question in oral exams is that limitation period time for adverse possession. And that's what I've said is 12 years, and it will never miss. So that's one mark added to your basket. So perhaps back to now section 32 of the Limitations of Actions Act, which provides for the enjoyment of 20 years period for one to acquire an easement through prescription. So the other type of question you could be asked is on the difference between prescription and adverse possession. So section 37 and 38 of the Limitations of Actions Act, if the land itself is registered, then it is held in trust from the adverse possessor until he or she obtains a vesting order from the High Court. Okay, so what are the essential elements on this? One, you have possession of the adverse possessor is neither by force or stealth or under the license of the owner. Two, you have, it must be adequate in continuity, in publicity, and, in extent to show that the possession itself is adverse rather to the title owner, okay? And then you have open and notorious use. You have intention to possess. You have continuous use. You have exclusive use to the exclusion of the owner. And then you have actual possession. You also have non-permissive, or hostile or adverse use without owner's permission and inconsistent with his rights. So this is another question in oral exams, the essential elements of adverse possession. Note that, please. Okay. So summarized again in the Latin maxim of nec vi, nec lam, nec precario. Another common question in oral exams. So this Latin maxim basically means it is neither by force nor secretly and without permission. So nec vi, nec lam, nec precario. Okay. So the doctrine itself, the doctrine of nec vi, nec lam, nec precario, it does protect litigants from long and dormant claims. Because you could be asked in the oral setup, what is the implication of this particular doctrine? So it does protect litigants from long and dormant claims. So again, to leave land abandoned, will be contrary to the principles of the land policy enshrined in Article 16 of the Constitution. Okay. So the procedure for acquisition of title to land through adverse possession or prescription, another common question. So this procedure is provided under Order 37 of the CPR, 2010. So the application made through OS, supported by affidavit, to which a certified extract of title to land is annexed. Note that it is through OS, okay, supported by an affidavit, to which a certified extract of title to land is annexed. So see Article 40 of the Constitution. Look at sections 9, sections 10, 11, 12, 13 of the Limitations of Actions Act, and also look at the case of Chevron Kenya Limited versus Harrison Charo Washutu. That's a 2016 case. Chevron, Chevron, Kenya Limited versus Harrison Charo Washutu, a 2016 case. Also look at the locus classicus of adverse possession, another common question in oral exams. Mtanaleo versus Kahindi Ngala Mogandi, a 2015 case. You also look at the cases of Karanja Madheri versus Kanji. Karanja Madheri versus Kanji. Kanji is Kanji. That's a 1976 case. Look at the case of Gatimu versus Kinguru. Okay. Look at the case of Bwana versus Ibrahim. And then, for the lovers of the English jurisprudence, you can look at volume 20, page 699 of the Hasbury Laws of England. I don't know if it's in the library at KSL, I'm not sure. So volume 20, page 699 of the Hasbury's Laws of England. Okay. And then the last part of involuntary transfer is compulsory acquisition. So application for compulsory acquisition. So the National Land Commission, please get this right, another common question, even in the bar and oral exams. So application for compulsory acquisition. So the National Land Commission receives a request, okay? Someone's make his own. So the National Land Commission receives a request for acquisition from the acquiring body pursuant to section 107, subsection 2 of the Land Act, okay? So the acquiring body confirms with NLC in writing that it has sufficient funds for the intended acquisition. And then thereafter, the National Land Commission, to satisfy itself that the geo-referencing of the land to be acquired has been done. Okay. Then now there's notification of the proposed acquisition. So here, the NLC will publish what we call a notification of intention to acquire the land in form LA33, okay, in the Gazette. Remember, it's form LRA33, but we have also form LA33. Reason being, one is for the Land Act, the other one is for the Land Registration Act for transfers, okay? So in form LA33 in the Gazette, in at least 2 daily newspapers, with nationwide circulation, 1 local newspaper, and affix notices at the county, sub-county, and ward offices. So the NLC will serve the notice of intention to compulsorily acquire the land to affected persons and register in accordance with section 131 of the Land Act. So after this, the registrar shall, upon receipt of the said notification, make an entry of the intended acquisition in the register. And then after doing this, the commission, now the NLC, shall, in consultation with the affected persons, inspect and collect data on the location, the area to be acquired, the proposed land use in the national, regional, and county spatial plans. You have, existing use of the land, improvement of the land being acquired, the impact of acquisition, etc. And then the other step is the issuance now of the notice of inquiry. So here the NLC, shall issue a notice of inquiry in form LA34 to every person whose interest appears in the register and who claims to be interested in the land. But what you have to note is that this notice of inquiry to be published or has to be published in the Gazette in at least perhaps 2 dailies with nationwide circulation. Again, also in the county Gazette, the respective county, sub-county, and ward offices at least 15 days before the date of the inquiry. Then the NLC will, upon expiry of these 15 days, conduct an inquiry to hear and determine issues of proprietary and claims for compensation by persons interested in land as provided under section 112 of the Act. And then the other step is now the valuation of claims and interest. So the NLC here will carry out valuation of interest or claims, determined at the inquiry for purposes of determining the full and just compensation to be payable to the persons whose interest.
Davins, you've muted yourself.
sorry. What is the last thing I said? Evaluation, I think. Yeah. So for valuation of claims and interest, the NLC will carry out valuation of interest to claims determined at the inquiry for purposes of determining, the full and just compensation to be payable to the persons whose interest or claims have been determined, and inform the acquiring body of the cost. Okay. So the determination and assessment of just compensation to be in accordance with the land assessment of just compensation rules. And if you haven't downloaded these rules to date, please do download those rules, the land assessment of just compensation rules. The next step is rather the preparation and service of the award. So the NLC prepares an award, which shall include the size of the land to be acquired, the value of the land to be acquired, and the amount of compensation payable to persons with interest. Okay. And then the award and offer for compensation to be communicated in Form LA 35, and then the acceptance and or rejection of the same to be communicated in Form LA 37. Okay. So the bona fide person, forwards the bank details, the PIN number, and ID documents to the commission. And then a party aggrieved by an award to refer the matter to the Land Acquisition Tribunal. Please note that, the Land Acquisition Tribunal. Okay. So the next step is the payment of compensation now, as we near the end of my presentation. So for the payment of compensation, the acquiring body, deposits with the commission the compensation funds in addition to survey fees, registration fees, and any other incidental cost. So the NLC again will pay the award within 90 days from the date of receipt of the funds. Okay. And then the landowner shall, within 15 days of receipt of compensation, surrender the original title to the commission, who shall prepare, surrender documents to be signed by the proprietor and forwarded to the registrar. And in the event the acquiring body is only interested in a portion of the subject land, the NLC, shall, before the payment of compensation, cause a final survey of the acquired land to be carried out, and preparation of cadastral maps, and plan to be put in place. Then the next step, in the third last step, the registration of the acquired land now. So here, the registrar, registers the acquired parcel in favor of the acquired authority, and registers the remaining parcel in the name of the proprietor where applicable. Then the next step is the surrender of the land now. So the NLC takes possession of the land on a specified date upon service of a notice in Form LA 39 to all persons interested in the land. Okay. So my presentation has come to an end. So at your free time, at your convenience, please note this down. You can describe the procedure followed by a public body to acquire temporary occupation rights over land. That's a common question, both in the bar exams and the oral exams. Describe the procedure followed by a public body to acquire temporary occupation rights over land. Okay. And again, at your convenience, please read Part 8 of the Land Act and Part 7 of the Land Regulations of 2017. So with that, ladies and gentlemen, I'll cap it up. Back to you, Salonga.
Well, thank you. Noah also was to give something in brief. Then now we go on to the orals. Somebody has a question. Please go on.
Yeah,
I saw raised hand.
Who will that be? Please feel free. What question do you have? And hopefully I could address it after Noah's presentation, for the sake of time.
Okay, no, you can go on now. Then now we go on to the questions.
Yeah, Noah, please.
Okay, good evening. Am I audible, Salonga?
Yes, you are.
Okay. So 2 weeks ago, I asked a student a question on discovery. So I thought it wise, given that most of these lecturers give very little knowledge in this particular area, they tend to pose it. And when I was in KSL, I found this particular area very important, and I thought it wise if I could share, take a minute or two to share it with the students. So the first paper which I'm talking about is, I think, 2019, question 2. When I went through that paper, I realized I was never taught anything. Even what the teacher said mostly did not even apply. So I thought it wise to go over discovery in 10 minutes or so. So I'll just take a snapshot of the case laws that I researched. There are around 8. So I'll just take a picture and send it to the 4 groups so that we take the least time possible when discussing this. So discovery, I believe discovery is so essential and so central in civil litigation that the entire previous Order 11, the pre-trial conference of the CPR, Order 11 had been devoted to it. So we realize even if you go to Order 4 and Order 7, there's a requirement that parties ought to file and serve documentary evidence with their pleadings. So another order which is very important also is Order 14, which empowers courts to order production or impounding or returning of documents. This is now what we call discovery. For instance, I asked a student where somebody filed an ELR claim for reasons of dismissal. The reason as to why those people maybe dismissed you is the issue of forgery of certificates. So in your pleading, in your statement of claim, you have annexed you are probably the next certificate, and maybe you had a D+, but the defendants or the respondents on their part, they're saying they forged. So when they're responding, they said, no, you forged your certificates, that's why we are firing you. However, in their pleadings or in their response, they have not annexed any document showing that I have forged my certificate. So what you do, you make an application, and that application is normally not by notice of motion. You do a notice to produce, you file it in court. So it's a notice to produce. So the reason as to why you are doing that is because, one, it's a discovery. One, the purpose is to level the litigation field. Number two, when you request for such documents, is basically it's also a way of expediting hearing. It reduces cost and allow the parties to gauge their case, the case which they are going to face at the trial. So, like I said, discovery is so central in that the entire some of the orders in the CPR, Order 11, Order 4, Order 7, Order 14, have been, set aside for the issue of discovery. So when it comes to discovery, you realize that, or what happens is that, and when you read these case laws that I'm about to send, discovery should only be limited to matters in contention. It should be limited to matters in contention. By this, I mean that the issue that you are seeking the other party to give you, or that which you wish to inspect, must be relevant. It must be of relevance vis-a-vis the pleadings or particulars that have been provided. So the court must satisfy itself that a party who seeks to introduce or produce will not be for the purpose of altering the course of action. All it needs, the reason as to why you seek the other party to produce should not be for the purpose of altering the course of action. basically what you need to do is the issue of litigation, the playing field being leveled. So when you look at the Husbandry laws of England, volume 13 at I think paragraph 38, it states that the court won't make any orders for documents that have no relevance to the matter. The court won't make orders for documents that have no relevance to the matter. And there are certain cases which another reason as to why discovery is there is to ensure that all documents or information necessary for just determination of the suit are made available to the parties as well as the court. So the tests when it comes to discovery is the issue of relevance, and it must be necessary to the proceedings. The question that the court will ask themselves when somebody has filed a notice to produce is the question that are they directly connected with the suit, and will they assist the court in determining the real issues in controversy? Will they completely assist the court in determining the real issues in controversy, or will they effectively tackle them? And another basis for discovery is Article 35(2). Then we have Section 22 also of the Civil Procedure Act. So there must be a compulsory disclosure. Basically what this act says, these legislations, is that there must be a compulsory disclosure at the request of a party. So there are other cases like Rafiki Microfinance Bank versus Renith Pharmaceuticals. It says discovery will not be ordered in respect of an irrelevant allegations in the pleading. That is that which could not affect the result of an action. So if you are seeking, if you have filed a notice to produce, where you make irrelevant allegations, then the court will deny you. The court will dismiss that particular application. So, like I said, those applications that you make, which allow you to fish new witnesses from the other party, the court will not allow. Then another test, apart from the issue of relevance and necessity, the other thing that the court will look at when you file a notice to produce is the issue of the document being a specific document, not a general. And when you look at the past paper, what that party was looking for, what he stated in the notice to produce, when you look at number 2, question 2 of 2019, and I'll read it, the documents to prove the validity of title of LR number 1 of 2019 acquired by the defendant. The documents, you see, that is not a specific document that he intends to acquire from the other party. So the court will dismiss when they realize that when you have filed a notice to produce, and one of the grounds or what you seek is the documents to prove the validity of the valid title of LR 1 of 2019, then it's not how can I say, it's not a specific document you seek to extract from the other party. It's a general document. So that's another test that normally courts look at. And then that document that you also seek to extract from the other party must be in his possession. So those are the 5 or 4 tests that when you are doing a notice to produce, you have to check. 1, is the document necessary? Number 2, is the document relevant to the suit? Number 3, is that document in the possession of the other party? Number 4, is that document or that document you are seeking, is it a specific document, or what you are writing there is a general document? You know, you have to be very specific on what you want. And then lastly, what another test that you'll also have to check is the issue of ambiguity. The document or what you seek from the other party ought not to be ambiguous. So those are the tests when you are talking about notice to produce discovery. And I've sent certain cases. When you look at Oluoch versus Charagu, it says that omission to prove possession or power and relevance is fatal to an application or notice to produce. So when you omit to prove possession or power and relevance in your application, it will be fatal. So that's basically a snapshot of what I wanted to discuss. When I'm sending the case laws, you read them. They are very important. So when you want to extract an information, basically what I'm saying, when you want to extract certain information from the other party, which they have not annexed in their pleadings, you do what we call a discovery. So one of the things that you must prove or must come out clear in your application is that one, the document is relevant. Number two, the document is necessary. Number three, the document must be in the possession of the adverse party. Number four, the document sought must be specific. You know, that the issue of the question, one of the things, the mistake that person did, the plaintiff did, he wrote in the notice to produce that the documents to prove the validity of a title, you know, he has not specified what document he wishes or she wishes to extract from the other party. And then lastly, the document ought not to be ambiguous. So those are the tests that the court will look at. So when you are moving the court under discovery, you do a notice to produce. So you, as the person who wishes to respond, you will either do a replying affidavit or the necessary thing where you find that the plaintiff or the claimant or the person who wishes to extract any document from you has not met the tests, any of the tests that I've stated, then you do a ground of opposition. So Solonka, that is all I wished, because there's no much time. We wanted to do the oral mock-up. That's all I wanted to share with the group. Thank you. I'm sending the case laws I have reached.
Thank you so much. Thank you so much, Noah. Thanks a lot. I remember issues to do with discovery or the one in general was a bit challenging, and we studied it the last time. I don't know if Alex is in the meeting, because we were with him when we were studying this topic. I see Sumaya. Who did I see? Yeah, no, it's just Sumaya. Sumaya is also in today. Yeah, so it was a bit challenging, but yeah, we managed to hack through it. Since Sumaya has joined and she hasn't been here for a while, I'll give her the next opportunity. But I also see we have a new member, a colleague of mine, Miss Mwangi. We've not been having ladies in this forum, so I'd let Miss Mwangi introduce herself, and then Sumaya to, if she's ready, to have a few questions. Since she's not been available, then Miss Mwangi can follow up after her. So since we've never heard from Miss Mwangi, she can introduce herself, then Sumaya can proceed to give a few advice, ask a few questions, and then Wanze will follow up. Or kindly, please raise your hand if you're willing to be asked questions first. Remember, the more you practice, the better you become. So raise your hand or I just pick randomly. Who's willing? I also see Alex is in. Today we are a bit many, so we'll cover as much ground as possible. So who wants to volunteer? Who's going to raise? Oh, I can see Wangila Brenda. So Sue, after Miss Mwangi introduces herself, you can proceed to ask Miss Wangila. Is that okay, Sue?
Perfect.
Then Miss Mwangi can follow up after you. You know the way we do 2-2, like the way we normally do our oral workups. So Miss Mwangi, you can introduce yourself, then Sumaya can take over so that you see how we ask questions. Then you can prepare you as a Sumaya asks questions. Ask Miss Wangila a few questions. Then after that, we'll follow up with Alex after the next. Okay. Please go on. Thank you.
So, hi guys. I'm Evelyn Wanjiru Mwangi. I'm friends with Pareno Solonka. He requested me to join you guys, and it's been a long time coming, but I'm happy and glad to be here with you and during your oral mock-ups. I wish you all the best, and as he said, the more you participate, the better you become. And I wish you all the best. May you all get your target scores.
Hello, hi everyone. Yeah, so it's Sumaya or Maya. Of course, most of you know me, but yeah, I'm sorry, I've been MIA a bit for the last couple of weeks. I was doing a job transition, and it's I was a bit unavailable. I didn't have a lot of time for this, but I know orals is coming up soon. I just wanted to check in on you guys, make sure you're all okay. Of course, I hope you're controlling the nerves. The nerves are a lot at this time, but just try to read as much as you can, sleep, the general things. I know you might not get someone to reassure you about this all the time, but yeah, please take time to rest and read as much as you can. So I just wanted to say something that just touch on case management. This was something that was highly predicted when we were doing the bar exam. I remember people were talking about case management a lot, and I realized we only discovered a lot about case management towards the bar exam. But please make a point of reading on it, especially what Noah talked about in terms of discovery. There's a lot of changes that have been done to the civil procedure. So you need to know, how does a party object? And what I came to come across is that the grounds of objection, which Noah mentioned, are usually done in affidavit format. So the other party will do an affidavit, saying these are the reasons why they're not willing to comply on discovery. Maybe the document in question is irrelevant, etc. All the grounds is mentioned. So please look at it and just know that case management is something very important for civil procedure, because that's where you see whether a case will go to trial or not. And that's also where the court usually opens the room for ADR and other forms of negotiation before now starting the hearing. So just make sure you have an idea about that. So I think we can go straight to the oral mock-up, or is there anything else we need to cover before then?
Nah, Sumaya, you can go next. Then if they have questions, they'll ask.
Okay, perfect. Sawa. So is the person I'm asking the questions ready?
Miss Wangila Brenda.
Yes. Hi, Sumaya. Can you hear me?
Hi, how are you? Yes, I
Fine,
can hear
thank
you. How are you doing?
I'm doing fine, thank you.
Please tell me something about your name.
Pardon?
Please tell me something about your name.
Thank you for that question. My name is Brenda Wangila. I am a student in Class D, the afternoon class. So my name is used to identify me, and a name is important. I was allocated to it at birth, and as it's part of my birthright under Article 53 of the Constitution. So apart from identifying me, it also enables me to relate and show where I come from. So it's part of identity and community and belonging. Thank you.
Okay, thank you for that. So I'm going to, okay, this would have been better if we were actually doing it physical, but okay, let's say one day you walk into a room and you see two people, let's say me and Solonka, you see us fighting over a phone, right? And Solonka is screaming, "No, this is my phone," and I go like, "Oh no, this is my phone." So you walk in, and assuming you're an advocate of the High Court of Kenya, what would you file in court?
Thank you for that question. So As an advocate of the High Court of Kenya, I took an oath of office as an officer of the court to assist parties in resolving their disputes and ensure that they get justice. So if I saw two people fighting over a phone, my first reaction would be to try and separate them, to amicably resolve the dispute between them using the various methods of alternative dispute resolution under Article 159(2)(c) of the Constitution of Kenya 2010. And I would not need to go to court per se, but if I was the prosecution and one of them filed a complaint with the state and I as the prosecution representing the state, then I would ensure that they file a complaint with the police. After a complaint is filed, a charge sheet would be, there would be recorded a charge sheet from which the matter would proceed to trial in the criminal process. Thank you.
Okay, thank you for that. So maybe for our last question, what do you think about the Kenya and Somali maritime dispute issue?
Thank you for that question. So recently, the International Court of Justice adjudicated over the Kenya-Somali maritime dispute, which was forwarded to the ICJ by Somalia sometime in 2014. What I think about it is that probably the formal process of court would not have been suitable in this instance because Kenya and Somalia have long-term ties since time immemorial, and in this instance, I would say the normal court process would not be the best alternative, and it will just lead to more tension within the region. Instead, I would advise that the AMISOM be involved. The African Union be involved and try and reconcile the parties to ensure that there is peace in the region and that there is stability. Thank you.
Okay, thank you for that. So I think I'll just go straight to the comments. First of all, really nice presentation. Your tonal variation is on point. In terms of your voice coordination, I think you can improve a bit on the arms and the end. I know we usually say them a lot, and it's a very normal part of speech for all of us. But try to, towards your oral exam, try to minimize them as much as you can. Yeah. So for your three questions, first of all, for the name question, I definitely loved how you mentioned the Article 53 reference. That was really nice. I never thought about that. That was a very, very good answer. But I also feel like when you asked about your name, you can also speak about how when you're changing it, you can use a deed poll, if there are any errors, you can use an affidavit, etc., etc. So I think that was the only thing I felt that was missing in the first question. But other than that, you answered it well. Now to the next thing, every time you're receiving you're trying to receive a question and you're starting the answer, you don't have to start it with "thank you for your question." You need to show the panel that you're not a robot, right? So you can say something like, for the first one, you can say "thank you for your question." For the second one, you can say, "That's a very interesting question." The next one you can say, I don't know. There's a list of things I wrote. In fact, I don't know. I think there are a couple of them. I might have shared them in the group, but I can check. I can check and send a screenshot. But there are a couple of different things you can incorporate. Sawa, just so that your answer it kind of looks organic. You also seem like you're having an interaction with those panelists. Now, the reason why I'm telling you this is because there's a friend of mine who we had practiced. When we were doing our mock orals, we always used to incorporate "thank you for your question," And then when he went there, the panel gave him a caveat and they told him, please don't even, tell us things like "thank you for that question." Go straight to the answer. Hello, guys, can you hear me?
Yes, Maya, I'm following.
Yes, we can.
Okay.
Yes. So, yes. So,
Yes, we can.
So find. Okay, perfect. Thank you so much. So find organic. yeah, so I'm saying find organic catchphrases that you can easily slide and incorporate. I don't know. Thank you for the question. So there's a couple. I'll send a screenshot to the groups right now. But there's a couple like, thank you for your question. That's a very interesting question. etc. There are a couple of them. So try to find a way of incorporating them. Sawa, and usishinde kurudia the same phrase. I am. So the third note. You see, when I asked you the question about fighting for a phone, there's something specific I was looking for. So this question actually comes exactly from an experience a friend of mine also got during the orals. So when they walked into the room and the orals, after the whole introducing yourself, blah, blah, then the panelists started fighting over a phone. So it was Miss Mongari and someone else, I don't remember the other person. And as they were fighting for the phone, they're like, oh no, this is my phone. And I was like, oh no, this is my phone. So then they asked my friend, what would you do in that scenario? So the reason why I mentioned an advocate of the High Court and the reason why I asked you what would you file is because I'm looking for something very specific. I liked how you were able to think on your feet and mention the thing on dispute resolution in Article 159. That was really, really nice. I really like how you reference the Constitution, and that's a very good tip. Please continue with it because I feel like that also helped me during my exam. In every single question, I referenced the Constitution and laws were applicable. Yeah, but what I was looking for an interpleader. I'm not sure if you've studied that yet, but generally an interpleader is filed where there are two parties, where there's a third neutral party, and there are two parties fighting over a property. And the interpleader, there's certain conditions of how when you're an interpleader, and there are scenarios where it's either the suit property either has not gone to court yet, or there's an existing case. And in this scenario, interpleader will come in and they will show the court that they're a neutral third party and they're only interested as to certain costs. For example, if you're a cargo holder and me and Solonka are fighting over the cargo, right? Or a scenario like that. So what I was looking for specifically is the word interpleader. So this goes back to when you asked a question, be very, very keen, listen to the question till the end. Because you see, when I asked you the question, what would you file? The first thing you should think about is a pleading. So either a pleading or an application. That's the first thing that you should think of. And then immediately you ask the question, just take a second to digest it. You don't have to immediately, answer the question. Just take a second. I'm not saying take too long, but take a second to digest it because you might miss something very crucial as to the ending of the question. But I really liked how you thought on your feet. That reference was really nice. The alternative dispute resolution was very nice. The fact that you mentioned separating the people who are fighting is a very good, a very good spot on, answer. And then for the last question, about the ICJ. Okay, first of all, the reason why I asked you, what do you think? That's an opinion question. Yeah. And sometimes lecturers ask about opinion questions, other times they shy away from opinion questions. So, and something like this Kenya and Somalia, case that's going on is a case that has a lot of opinions around it. Yeah, and you'll actually be shocked to see that some lawyers like us don't also fully understand what's happening in terms of that dispute. So what I'd say is to be safe, understand, have a background of the case. That's the first thing. Mention that this case is, regarding the maritime delimitation, and there was a previous agreement between Kenya and Somalia. So when you ask about what I was trying to see if you'd actually take a stand on this issue. Because in this issue is an issue that has a lot of quote unquote patriotism in it, yeah. So what I was trying to see is, what I was trying to bring out in that question is, avoid having your own personal opinion when you ask about personal opinion questions. Sawa, that's the safest way to go about it. Or if someone asks you, counsel, what do you think about the BBI case? Do you think it's, a reasonable way of, how Kenya should be? Avoid talking about a personal opinion. Don't mention it. Whether you're pro BBI, pro anti-BBI, don't mention that. Talk about the substance of the case, talk about actual legal issues. So for that case, Somalia ICJ question, I was looking for a background of the case. Just have an idea. It's a current, ongoing matter, and I think I saw a statement that was released by Somalia today. I'm not sure if it's a legitimate statement, but it's the statement released by the Somali government. So make sure you have an idea about the case. Just review, understand what the dispute is about, and understand the backbone of the dispute. And then, of course, you can also mention things like what you said, that Somalia and Kenya are neighbors, and those probably, there should have been more negotiations in terms of the use of that coast. Yeah. So I think, yeah, that's it. Other than that, very good trial. I think you're 99, let's say 98, 99% ready for orals. Yeah, just polish up on your answering. I think also your structure is very good, but try to polish up a bit on how you put your structure. Voice tonation, everything perfect. Work on the arms and the end, okay? And how you begin your questions. I think that's it. Also, if you can find a way of sometimes signaling the end of your answer, like for example, you can use words like in conclusion, to close, as a last point I wish to state. Those things also help, with the panelists to know that you're almost done. Yeah.
Thank you, Maya. Thank you. That's really helpful.
Welcome.
Thank
All
you
the
so
best.
much, Maya. Thank you so much. Wangila, you did great. You are, as she said, 99% ready. You did great. I saw another hand raised up. Is anybody else wants to give it a shot? Masibo, nice. Okay, thank you. Now, Masibo, Alex, Alex, are you in?
Yes, I am.
Alex is in. So Alex and I will take you through a few questions. Then one Miss Mwangi will take you. Okay, Miss Mwangi will take you through the last. Okay, we will be three panelists in this circumstance. Since Miss Mwangi is new and she doesn't know how we go about this yet, Alex and I will provide a precedent of how she'll go about. Then she can ask you a few questions. Is that fine, Masibu? Is that fine, Mr. Masibu?
Okay, yeah, it's right. It's fine.
Okay, no problem. So, okay, let me begin. Then Alex will follow. Then Miss Mwangi. Okay. Now recently there's been in the news. There's been this question on the ICJ. Now, as a lecturer, kindly explain to me what's the difference between the ICJ and the ICC? What's the difference between the ICJ and the ICC?
Okay, that's an interesting question. So, the ICC usually deals with the matters concerning crimes against humanity. It deals with criminal matters, international criminal matters, whereby the ICJ, it's a court of justice where the matters there are usually more of civil matters between countries, or in other words, between states. Okay, that's the difference I can adduce between them. Okay, thank you.
Thank you very much. You have a good grasp of international law. Now, my next question will be, what are preemption rights? And why do we have preemption rights? What's the essence of having preemption rights?
About the preemption rights, I'm not knowledgeable about them, so I stand by the thing.
Okay, no problem. Thank you for that. My next question will be, can you give me the different parts or the different contents in a sale agreement? In a sale agreement for the sale of a piece of land, what are the parts or the elements or the contents of a sale agreement for the sale of land?
Okay, thank you for the question. So, there is the general conditions. Then there is the general conditions. Then the special, or can I say, okay, special or specific conditions. Okay, that's what I can remember about the elements. The specific conditions and the general conditions.
No problem. Thank you for that. Now, My next question will go into professional ethics. What's your understanding of conflict of interest? And kindly give me any scenarios where a conflict of interest will arise.
Okay. That's also another interesting question. Okay, conflict of interest, from to my understanding, is where there is a it is where a matter arises and the neutral party that is supposed to decide on the matter that has arisen is seen to have an interest in that matter. So that's where there can be a conflict of interest. So, for example, where like in matter succession, for example, where there is a will and the witnesses is among the inheritors of the or the beneficiaries of the will. So the witness who is the beneficiary will have an interest, will create an interest in that property that is being that will be administered due to that will. So that one will create a matter of conflict of interest. Okay, thank you.
Thank you for that. Thank you for that. Now, that last question will be, what's your understanding of human resource management in the area of legal practice management? What's human resource management in the area of legal practice management?
Okay, human resource management is the money in the area of legal practice is the management of let me say it is the management of the employees in a firm.
Okay,
whereby,
thank you.
Yeah, thank you.
Thank you for that. Thank you for that. My last question will be, actually, no, that was the last question. Thank you. Thank you for that. Wait. When do parties in a conveyancing transaction need to acquire an LCB consent, Land Control Board consent? And what act of parliament governs issues pertaining to obtaining the consent of the Land Control Board?
Okay, thank you for that question. I think you need to acquire the LCB consent when you are dealing with agricultural land, and on matters of the statute that governs the control. I'm not aware of them. Maybe I stand guided on the same, but it is where it governs the agricultural land. Okay, thank you.
Thank you so much. Thank you so much. That's a very good attempt. Now I leave the floor to my colleague Alex, who will ask you a few questions. Then yield the floor to Ms. Mwangi. Thank you so much. Alex, welcome. Then I'll give out my comments thereafter.
Okay, thanks, Solonga. Good evening, Masibo.
Okay, good evening, Mr. Alex.
How are you?
I'm fine, thank you.
I'll just ask you 5 questions. Can you hear me?
Yes, I can hear you.
Yes, I just want to ask you 5 simple questions, and then I can give you my feedback later. So the first question: can you distinguish between a limited partnership and a limited liability partnership?
Okay, a limited partnership is where the partners are the partners, where the partners are personally liable in equal quantity of the liabilities of the partnership, while a limited liability partnership is where the partners are liable to the extent in which to the extent of their shares in the partnership. Thank you.
Okay, thanks. My second question is, what is the Cabral rule?
Okay, thank you. That's an interesting question. Okay, the Cabral rule originated from the United Kingdom, whereby there was a case where the cab, or let me say the cabs or the taxi, were, maybe there was a case where they some taxis used to choose customers like they could choose customers. So there was a holding that the taxi or the cab should not choose customers, but should serve all the people without discrimination, whether you're comfortable with the customer or not. So it applies the way on how it applies to our legal regimes. It applies whereby you don't have to choose a client. You are supposed to serve any client, regardless of whether you like his or her opinion, her stand, or her behavior in the society. Thank you.
Thanks. My third question is, what is a merger?
Okay, a merger is can I use the word, a consortium whereby two companies have come together and joined to form one company or one consortium or one body. So that's what I can describe. That's how I can describe over merger.
Okay, thanks. My second last question is, give me 5 qualities of good legal writing. 5 qualities of good legal writing.
Okay, thank you. The qualities of good legal writing, it should be coherent, it should be precise, it should be straight to the point, it should be be having simple plain English, I mean. Then okay, those are the qualities that I can apprehend in my head. Thank you.
Okay, finally, distinguish between bankruptcy and insolvency.
Okay, thank you for that question. So bankruptcy is whereby an individual cannot pay his debts, or his assets cannot are less than the debts that he or she owes the creditors or the debtors. This is whereby an individual's assets cannot, or they cannot be able to offset his or her debt even if they are used. Whereby an insolvency is the same case, but it involves a company, whereby a company is unable to pay its debts, and the assets cannot be used to offset the debt because their value is less than the debt that is owed by the company. Okay, thank you.
Thanks a lot. I think Solonga should give his feedback, or before you go to Mongi, or how should we go about this?
Since I'm seeing Danson's. Danson, is your hand up?
Yes, Solonga, my hand is up.
You wanted to be asked questions, yes?
I wanted to be asked questions.
Okay, no problem. Okay, I'll give my feedback, then Ms. Mwangi will begin with asking you a few questions. Then after Ms. Mwangi asks you a few questions, Lavins can proceed and ask you.
Fantastic.
Okay, no problem. Okay, then I can give feedback to Mr. Masibo. So, Mr. Masibo, that was a good attempt. You tried. I loved how you answering the questions, calm, composed, and you managed to answer. And those that you didn't know, you just instead of beating around the bush and giving a wrong answer, you just passed it. So fairly good attempt. Now to go through the few questions I asked. My first question was on the ICJ and the ICC. You got that one correctly. The difference between the two is with regards to jurisdiction. So the ICC prosecutes individuals, as you rightly put out, for contravening their own statute. So crimes against humanity, genocide, and so forth, that's the jurisdiction of the ICC. Whereas for the ICJ, as you rightly pointed out, it's some sort of civil court which adjudicates disputes between two warring states. Yeah, so for instance, in Kenya, the ICJ, the recent ICJ Somali dispute was solved by the ICJ. So you got that one fairly correctly. The other question that I asked was with regards to what are preemption rights. Now, preemption rights, the topic is found under commercial transactions, and it's a principle that is governed by, I can say, three main sources. Okay, not sources of law per se, but they're governed by two main. How can I put it? Okay, it's governed by a statute, the Companies Act. It's also governed by the share purchase agreement between a shareholder and the company. And it's also governed by the Articles of Association. So they're not laws per se. The only law there is the Companies Act. But the other instruments that govern preemption rights are the share purchase agreement, the shareholders agreement, and the Articles of Association. So preemption rights, in simple terms, refer to the right of first refusal. The right of first refusal. That's actually the other name of preemption rights. The right of first refusal, which basically connotes that before a company or the directors of a company issue out shares to the public, they first have to go to the existing shareholders and give them the option to either buy or refuse to buy it. So that's why it's called the right of first refusal. So before the directors of a company can issue out shares, if you read the Companies Act, it talks about equity securities, and equity securities are just ordinary shares. The company has to first issue it out to the current shareholders, and then they have the option of either buying them, and if they don't buy, after they refuse, then the company can now issue the shares to outsiders. Okay. Now, I asked as a follow-up question to the preemption rights, what's the essence of having preemption rights? The issue is dilution. The issue is dilution of voting power and even return on investments. So think of it this way. A company has 100 shares. There are 100 shares divided amongst 10 persons. And then the company decides to, or the company, not through the directors or agents of the company, decides to issue out 10 more new shares to outsiders. What will happen there is the current voting power will be diluted and the return on investment will be diluted because more shareholders will come in. So when you're dividing the dividend according to your shareholding, if last year you got maybe $1 million, it may be diluted to maybe 800,000 or 900,000 or so. So the whole essence of having preemption rights is to prevent the consequences of the new allotment of shares, which will dilute the voting power and the return on investments of the current and existing shareholders. That's why we have preemption rights. It's governed under, you can check the Companies Act from section 338 of the Companies Act. yeah, 338 read together with which one else? Yeah, from section 338. There are various other sections which you need to pair up, but that's just the gist of it. Preemption rights of first refusal, whereby before a company can issue out new shares to other members who are not the current existing shareholders, they first have to give that option to the existing shareholders to either buy or to refuse. Now, the next question that I asked was with regards to contents of a sale agreement with in the area of conveyancing. So, what are the contents of a sale agreement? So, a sale agreement has the following main parts. The following main parts can be classified into 5. The first one is the parties. That's the first bit. When you look at at a sale agreement, a typical sale agreement, the first thing you will see is the parties to the contract. So it will have the names of the parties to the contract, not the vendor and the purchaser. It will also have the address of each party, the vendor and the purchaser, and so forth. That's the first bit, parties. After parties, there will be now the description of the property. Now this one you can call it recital. These are the recital, where it normally begins with whereas the vendor is the proprietor of this XXX piece of land measuring this and this, the purchaser wishes to buy and so forth. So those are the recitals. It contains the description of the property. Are there any encumbrance in it and so forth. That's the second bit, the description of the property, where it's located, the acreage, and so forth. Okay. Now, after the recitals, you have the special conditions. The special conditions. Now, special conditions, just from the name, these are special because they are specific to a particular contract. It's not template. Yeah? So it's specific to a specific agreement. So a certain purchaser X and purchaser X and vendor X may have a different contract for sale of land from that of purchaser B and vendor B. So special conditions, these are the ones that are specific to a particular contract, and they include issues to do with vacant possession, the deposit, what deposit is to be paid. Is it 10% deposit? Is it 15% deposit? Is the purchase price being paid in full at the execution of the sale agreement, and so forth? So that's what we mean when we talk about the special conditions in a contract for the sale of land. They're specific to a particular contract. Sui generis to a particular contract. And then we have, other than the special conditions, the next part will be the general conditions. The general conditions. Now, under the general conditions, so you've had these, what's it called? LSK conditions of sale. Alex explained it last time, and the import of the LSK conditions of sale. So let's say, for instance, a contract is silent on when the completion date or what will be the completion date in a particular sale, in a particular conveyancing transaction, and a dispute arises, the parties will resort to, or the courts will resort to, the LSK conditions on the issue of determining or ascertaining what the completion date will be. So these are just general conditions that are usually there, and they fill in the gaps where the matters are not specifically covered in a typical sale agreement. So you have, for example, the completion date, issues to do with the notice to complete when a party fails to complete. And this is another question that I will ask later on, maybe if we get the chance and the time. What's a completion notice, and when is a completion notice used? It's a typical question that you will be asked in the oral exams. Also, if you meet the conveyancing lecturers, for instance, Mr. Ayera. Now, other than the general conditions, now you have down there the other, what can I call, not boilerplate per se, but execution and so forth. So if you're told to name the elements or the main parts of a contract, other than stating offer, acceptance, and so forth, you can now go specifically into those nitty-gritties. Start with the parties, define what happens in the parties, go to the recitals, what do you find in the recitals, and then you go into the special conditions, talk about, what clauses will you find, then go to the general conditions, what typical clauses will you get, and then go on to, you can expound. It's an open-ended question. There's so many things you can talk about in a sale, when you're told to name the contents of a sale agreement. If you can't grasp them, just close your eyes and then think about a typical sale agreement. What does it have? A typical sale agreement for the sale of land. What does it have? Then I'll try and break it down. There has to be purchase price. Explain it. It's self-explanatory. How is purchase price and the deposit treated in a sale agreement transaction for the sale of land? Look at the issue to do with completion documents. Yeah, it has to be captured in a sale agreement. Look at time is of essence clause. What is the essence of having a time is of essence clause? Yeah? If a party fails to comply within a required timeline, that will constitute a fundamental breach of the contract. Talk about what else? Interpretations. Wakati ukiwa in that exam and you can't think of anything else. There are interpretation clauses and definition clauses in a sale agreement. Talk about that. Yeah? Talk about representations and warranties. A typical example is, this is something that lawyers put in the agreement for sale, is that the vendor makes a warranty that the land which is being sold is not found in the Ndungu land report. This is a question that may also arise. What is the Ndungu land report and so forth? So it's a fairly open-ended question, and hope I've guided you on that. The other question that I asked was, which you answered perfectly, when do parties in a conveyancing transaction need the LCB consent? When do you need the LCB consent? Simple. When you're dealing with agricultural land, you have to obtain the LCB consent. Now, LCB is the Land Control Board, and the statutory provision that governs it is the Land Control Act. The Land Control Act. So you can go to Kenya law, check the Land Control Act. The most important question is, the most important section will be section 6. And another question that will arise is, what is the effect of a transaction which has gone through and the parties did not obtain the consent of the Land Control Board? Yeah, that's another question that may arise. The answer is, the transaction is null and void. Okay. You got that one right. The other question that I asked is regards to, what was it? Yeah, conflict of interest. Conflict of interest. Now, when I asked about conflict of interest, you can bring in, there are various case laws that you can bring in when answering this question. There is this famous case, King William Mills versus Kaplan and Stratton, to impress the panel. Bring out these case laws, bring out sections of the law, bring out SOPEC, the standards of professional practice and ethical conduct, and so forth. So conflict of interest basically connotes that an advocate has to be independent. Yeah, an advocate should avoid any situation that will bring a conflicting interest between him and his client. And there are so many instances where, when you're told to, for example, list instances where a party, where a conflict of interest will arise, there are so many scenarios. Yeah. One example, a typical example, you cannot have an advocate acting for the defendant and the plaintiff in the same matter at the same time. Another circumstance is, an advocate cannot appear in a matter where he is a potential witness. So if he may be called as a witness in this matter, he cannot appear in that matter. What else? There are so many instances where conflict of interest arises. There's this other famous case where we read, there's an advocate who gave who advised his clients to buy certain shares in a piece of company where he is a director. The courts held that is a matter of conflict of interest. So you can think on your feet and come up with any scenario. But the typical example, the typical scenarios which you can talk about are where an advocate cannot act for the same parties. An advocate cannot act for a party cannot act for a party to the detriment of a former client, of a previous client, or a potential future client, and so forth. There are various situations which may arise. So yeah. So try and bring out case laws, King Woolen Mills versus Kaplan and Stratton. That's the case again. It's the locus classicus case on issues to do with conflict of interest. And that's it. I don't know if I asked another question. Oh, the other question that I asked is with regards to human resource management. So human resource management, just from the name, it refers to the organizational function of the office, which deals with people. So this is the organizational function of the office that deals with matters relating to people, the human resource. So when you look at a firm, there are various resources. There's a human resource, there's a financial resource, there are machines, and so forth. Human resource management is tailor-made for organizing the human resource in the firm. So it's an organizational function that deals with the people. So what are some of the typical aspects that come about when you talk about human resource? Are hiring. That's a function of the human resource. Yeah. There is employee motivation. That's a function of the human resource. Issues to do with procurement. Human resource does this. And under procurement, another famous question that they usually ask is, what's the difference between recruitment and selection, and so forth. And there is what else? Yeah, anything that touches on the human resource in a firm, then that falls under the topic of human resource management, and you can bring out as much issues as you can within that specific area. And I think I'm done with answering all the questions that I asked. So Alex can give his feedback. Masibo, you did well. You tried, and yeah. Thank you for that. Thank you for that. Alex can go on and give his feedback, and then we proceed.
Okay, thanks. So I think he did well. He tried to answer the questions in an appropriate way. So just to recap on my questions and the answers, the first question which I asked was distinguishing between a limited partnership and an LLP, a limited liability partnership. The most basic distinction a person can give would be the acts which provide for these two types of partnerships. The limited partnership is provided for under the Partnerships Act 2012, and then the limited liability partnership are provided for under the Limited Liability Partnerships Act. So that's the first distinction, and a basic one. But the main distinction between these two types of business associations is that a limited partnership is a type of partnership where you find that at least one of the partners' liability is limited. So of course a partnership must have at least two persons. So when you find a partnership that has two persons, and then one of the partners has unlimited liability and another partner has limited liability, that's a limited partnership. So that's the main thing about a limited partnership. So even if there are 20 partners, you can find that two of them, their liability is limited, and then the other 18, their liability is unlimited. So you need to, that's something that which confuses. I think I said it here before. When it comes to limited liability partnership, all the partners have limited liability, just like shareholders in a limited company. All the partners in a limited liability partnership have a limited liability. So that's a key distinction, and of course, if you are likely, if you meet someone like Wakimani, or someone like Maloa, they tend to ask such questions. And my second question was the cab rank rule. I asked what is the meaning of the cab rank rule, and you give a good example why you give the history of the cab rank rule, but I would advise you can try to go to answer the question, as in you try to answer as fast as possible the question which is put to you before you proceed to other issues. So the history of the cab rank rule is as you said, the history of, even now when you go to Kenya to a matatu stage, the car that comes first to the stage is the first car which passengers board. So when that leaves, the car which followed it comes, and then passengers board, and so on and so forth. Same thing with the cab rank rule. The history of the cab rank rule is that in UK, when you went to a taxi, which are cabs essentially, when you went to their stage, the first taxi to arrive at the stage is the taxi which people would board, and then after it leaves, the taxi which followed it before arriving at the stage is a taxi which passengers would board, and so on. So that cab rank rule is what now applies to the legal profession. Essentially, that if a client comes to you, if there are two people, X and Y, let's say X is the plaintiff and Y is the defendant, and then you are of the opinion that Y has a good, X does not have a good case because of whatever reason, and Y has a better case, you cannot choose to represent Y if he came after X. So the person who comes to your office, or the person who contacts you first to represent them, is the person you should represent. That's how the legal profession is. And basically now the meaning, and my question was the meaning of the cab rank rule is that a lawyer cannot refuse to act for a client on any ground. Basically, that's the meaning of the cab rank rule. A lawyer cannot refuse to act for a client for any reason, including that he disapproves of the client or he disapproves of the case which the client has. So even if you don't like that client, or you do not see that the client has a good case, you should either way represent them if they came to you first. So that's what the cab rank rule means. Simple. There are many case laws which discuss the issue of cab rank rule. There's the case of Polk County versus Dodson. There's the case of Alan Westerfield. You can look at them and of course apply them in your orals. My third question was a merger. What is a merger? So if you are asked a question like what is a merger, you see when you ask what is a cab rank, there's no law which defines cab rank. The cab rank rule is just a common law thing. But now when you look at case law, they define what is a cab rank rule. But when you look at issues like what is a merger, there's a legal framework which defines what a merger is, which is the Competition Act. If you remember, it's good to frame your question in such a way that you appear like you know what you are doing. It just places you above other people. If you ask what is a merger, and I say a merger is when two companies come together and form one. True, that's the right answer, but have you answered the question sufficiently? Another person will say a merger is defined under Section 2 and Section 41 of the Competition Act. It is when two businesses come together to form one, either by acquisition of assets or acquisition of a business. So if one company acquires the business of another company, or acquires the assets of another company, or acquires the shares of another company, such that those two businesses will become one business, then as a result of change of control, then that is a merger. So essentially that's a merger. In layman terms, a merger is when two companies come together to form one. So my fourth question, which was my second last question, was the qualities of good legal writing. I think you answered this question. You're trying to answer this question well. And this is a question which you can be asked by someone like Kumu, because it is the first thing that Kumu teaches when she starts teaching legal writing and drafting. Qualities of good legal writing, and she will sing it through your entire period at KSL. Qualities of good legal writing are clarity, conciseness, making good choice of words. Remember those things: conciseness, completeness, elegance, precision, and non-ambiguity. Those there are around 8 or 9. If you look at the first lecture by Kumu, you will see those things there. Finally, my final question was to distinguish between insolvency and bankruptcy in Kenya. So insolvency essentially is when a company is unable to pay its debts when and when they fall due. That is insolvency. So if that's one, there are two forms of insolvency. Number one, when a company is unable to pay its debts as and when they fall due, and number two, that is called, they call it cash flow. Yes, cash flow insolvency. And then there's another one which they call balance sheet insolvency. Balance sheet insolvency is when the assets of a company are less than the debts of the company. So you find that a company has so many debts. Maybe it has debts of 100 million, and then it only has assets of 10 million. So there are two types of insolvency: when the assets are more than the liabilities, or when the company is unable to pay its debts as and when they fall due. That is insolvency. Bankruptcy, on the other hand, is when such a company has been taken to court and the court declares it to be insolvent. So it becomes bankrupt. That's how it is. So essentially, or basically, you only become bankrupt after the court has declared you bankrupt. When you look at Section 40 of the Insolvency Act, I think it was Section 40. It talks about what is bankruptcy. It in a way defines bankruptcy. It says when you go to court and the court declares you bankrupt, that's when you become bankrupt. Before a court has declared you bankrupt, you can only be insolvent. So that's the main distinction between bankruptcy and insolvency. Another distinction, which is usually in Kenya, is most people in Kenya say that insolvency applies to companies and bankruptcy applies to people. Yes, that's also true, but it is a layman's way of looking at things. But reality is that you become insolvent. You can be insolvent, but you're not bankrupt. But you cannot be bankrupt if you're not insolvent. So it is insolvency which leads to bankruptcy. You become insolvent, you are unable to pay your debts as and when they fall due, your assets are less than your liabilities. Somebody applies to the court, either the creditors or yourself, you apply to court, and the court declares you to be bankrupt. So insolvency precedes bankruptcy. So that's why I think you tried. I would say that you have a good flow in how you answer your questions. You try to answer all the questions. I did not ask any question which I would, in my opinion, warrant you to skip. That's another issue about you have to be wise. For me, I usually say for me, if you ask me some questions which I don't know, I have to skip because I don't want to appear like I don't know what I'm doing. But now when you ask what is a merger, what is the difference between an LLP and LP? You cannot skip such questions. You just have to try and answer them. Otherwise, you did well, and I wish you all the best. Thanks a lot.
Thank you so much, Alex, for that. Thanks so much. You did extremely well. You did extremely well. So we have Dan. Dan, are you ready?
Oi, Solonka, that is quite a strange name. My name is Edie.
Edie. Oh, Dan's Edie. Or Edie.
Yes.
Are you ready? Sorry for that.
Yes. Yeah, I've been out of circulation, but hopefully I'll be able to catch up with the questions as they come.
No problem. No problem. Maybe I can ask you two questions. Yes?
Sorry, I had raised my hand. I have a concern. I have a concern about the Land Control Board consent. Initially, like you, I thought the consequence of not seeking the Land Control Board consent is that it renders the transaction void. However, I came across two cases from the Court of Appeal that are contradicting each other. So maybe unless I am not aware of any Supreme Court judgment about it, I'm still confused about that. Maybe you can clarify.
Okay, thank you for that. I'm not familiar with the cases. I haven't read them. Maybe you could send them to the group and then, or maybe you can give us a brief facts. But okay, other than that, the reason why I was saying that the issue will be void of failure to get the consent of the Land Control Board will be void is because of Section 6, which I had mentioned earlier on, which talked about transactions that affect agricultural land. It's void if you do not get the consent. There's a specific timeline which is given. I don't know if I'll go check Section 6, but it's under Section 6, which provides for it being void for all purposes unless the LCB consent is given. Maybe it's 6 months or what after the sale of the sale agreement, but I'll go check on that immediately. But I give that password to Section 6 of the Land Control Board, of the Land Control Act, Land Control Act. So I can have a look at the cases. Maybe you can type it, or maybe you can give us the brief facts of the Court of Appeal cases. Were they contradicting each other, or did one Court of Appeal case give a contradictory ratio decidendi from another Court of Appeal case? Are they saying the same thing, or what are the facts? Because again, when it comes to judgments, you have to internalize them in light of the facts of each individual cases, or the facts presented before the court. But in the absence of those cases, I was coming from the point of Section 6, which is actually very clear. They're just saying it's void. And there's a timeline in which you need to seek the consent of the LCB consent. I'll go check, but what I remember, it's around 6 months or so. But then I'll get back with the accurate time frame. But maybe you can send the case or you can give us brief facts of it, then we can proceed.
Okay, I'll just send the case, but the reasoning behind the decisions that were, I read at least two decisions that were saying that the LCB consent does not really preclude. They were relying on Article 10(2)(b) of the Constitution, which they were saying that it elevates the principle of, the equity, the principle of equity. And in such a case, where the parties have already formed a common intent, there's a constructive trust between the parties, and the appropriatory estoppel is enforceable to it. Maybe I'll just send the case. The most recent was 2018, which was saying that the consent is not necessary, but the one which says the consent is necessary is 2014. So I don't know. Maybe I'll just send the case so that we can analyze it further. And yeah, for the timeline, it's 6 months. Yeah, I can confirm that.
Thank you for that. I actually now understand the reasoning. If we mentioned a constructive trust, it's based on the principle of, remember there was a time I was talking about quid close trust, issues with unjust treatment. I've not read the case, but from you mentioning constructive trust, I presume one of the issues was that money was paid. After money was paid, then one party is like, okay, I can't pay your money because the contract was void for all purposes. I'm sure, but just send me the case. I'll have a look at it right now as my other colleagues are questioning your colleague. Then I'll get back to you on the feedback of the case in around 10 to 15 minutes after they are done. But if they mentioned quist clause trust or constructive trust to be specific, then I think I have an idea of how that case was going. Okay, so just send it to me, and then I'll have a look at it. Edie. Karen.
Well.
Karen.
Yes, I'm available for you.
Okay, so I just have three main questions for you. Then Miss Wanzi and then Lavins will question you. Just three main questions.
All right.
Okay, the first one for me will be, what is a debenture document? What's a debenture?
Very well. A debenture is actually an instrument of, I would say it's actually a form of a charge against mostly the shares or the entire property of a company. And it's mostly can either be a fixed charge or a floating charge for that matter. And it's mostly registered with the Register of Companies over the movable assets of a company. So that actually is used to secure a loan or any other money equivalent or consideration for that purpose. And the charger or the person holding the debenture then is able to charge the assets, movable assets of that company.
That's very good. Very good attempt. Very good. Now, the other question will be, what are the requirements of a valid lease?
Very well. Leases are mostly provided for in the Land Act and the Land Registration Act. And one of the requirements, of course, is that the same has to be in writing, especially for leases beyond 2 years. But in case they are not in writing, then we'll have operations of, I think, Section 36 coming in, where then they'll be treated as just any other normal contract. The other issue is that indeed leases are mostly applicable for land for that matter. So we have a lease, and then we have the lessor, we have the lessee, and then you must have consideration for the lease. And then, of course, the lease has to also indicate the period, which the tenure of that lease, and of course, it has to have those parties, the lessor, the lessee, the consideration that is to be paid, and the tenure of that lease. And then, of course, it has to be in writing. Thank you.
Thank you for that. Thank you for that. My last and final question would be, I'll give you some brief facts. So you're a prosecutor in the Aroor Kimware Dam case. And then later on, you realize that the charge is defective. What will you do?
So being a prosecutor, and this one mostly depends on the at what stage does that realization come to, or your sales of that realization, because you can always amend a charge, of course, with the leave of court, but how you can do it first, you have the option of either withdrawing the charges against the person before any judgment is preferred, and then you rearrest the person and charge them afresh. Because remember, withdrawing doesn't mean that the person cannot plead out, refer, acquaint, or convict for that matter. So the best and plausible option as a prosecutor in the Aroor Kimorel Dam would be for me to withdraw the charges and then prefer fresh charges for that matter. Thank you.
Thank you for that. Thank you for that. Now I yield the floor to Ms. Mwangi, who will ask you a few questions, then yield the floor to Mr. Labins, who will ask you a few questions. Thank you for that.
Thank you very much, Mr. Solonka.
Hi, Mr. Danson.
Very well, very well. I really appreciate your presence today. We've missed the ladies in this session, and we don't take it for granted that you've created time.
Well, thank you. I'd like to ask you, assuming that this is the official orals, what you're wearing and why you dressed that way.
Very many thanks indeed. This is provided for in the advocates dressing rules that were promulgated sometimes in 2013, if I'm not wrong. And they require that indeed for any advocate must, and that is applicable for both male and female. There's a certain prescription on dress code. So in this session, definitely I'll be in a three-piece suit, gray, black in color, which then having matching shoes. Being black, then definitely I'll want to wear brown shoes, a very nice and subtle tie, and of course, being a person with beards, I'll definitely make them trimmed, and I will be then ready for the panel. So that will be the basis for my dress code. Thank you.
That is lovely. Are you familiar with the Huduma number case?
Yes, I am familiar with two cases on Huduma number, so I'll stand guided by which one you will want to probably interrogate.
Okay, in relation to both, kindly tell us about the principles of data protection.
Very well. And the first case was actually the Nubian case, which then the issues that were raised was that the information that the Huduma number, the National Integrated Management System was trying to do was to collect geodata and even DNA samples of persons just to confirm their citizenship and validity of probably their documentation. And that the court observed that indeed it was an affront to not only privacy under Article 31 of the Constitution, but then also it's just an infringement on the issues of the data that was being collected was not, the data was not, the government was not able to explain how they are going to protect or preserve that kind of data. And so the court found that indeed that requirement was unconstitutional. The second issue was on just the rollout of, again, the same Huduma number. And this was a recent case, which was must have been through Katiba Institute, if I'm not wrong, and several other people, VAG. And again, the prayers that were being sought were that indeed the appellate, or rather the dispute resolution mechanisms under Section 29 of the Data Protection Act, those were the petitioners were of the opinion that indeed that requirement was moot. So the government was not again protecting the data of people. And this, of course, and this has to be read in the context of Article 35 of the Constitution on access to information. And the Commissioner for Data Protection was not able to demonstrate, that is Madam Immaculate Kasait, was not able to demonstrate to court that indeed there are safeguards within which the Huduma number will be protecting people's information. So that is how I'll respond to that question. Thank you.
Okay. Define due diligence.
Pardon, just maybe in the context of conveyancing or commercial law, maybe just for clarity, if you don't mind.
I want you to define it, and then we'll come to the distinction in the processes in conveyancing and commercial.
Thank you very much for that question. Imagine you've just met somebody, a handsome young man, a beautiful lady, and you'll want to sort of settle with them. It's always advisable that you go a step further and establish where they come from, who is their mother, are they people who have means, or are they people who actually could be, people of wash. So you really want to just find out, go beyond the person's front value, and then establish their substratum as who indeed they are. And definitely that is what I'll say of due diligence, is going beyond the person and establishing other antecedent information about that person or a thing or any transaction. Thank you.
Awesome. Talk to us about due diligence in conveyancing and in commercial transactions. And if you could list the elements, that would be awesome.
Very well, and thank you very much for that. In starting off with conveyancing, this is one duty, and courts have stated time with no number that the role of advocates in carrying out or undertaking due diligence is something that is sacrosanct and must be undertaken. And we've seen several cases, of course, where our clients have lost because we never undertook this process of due diligence. So one of the key and fundamental processes under due diligence is to do what you call searches, and this involves both historical, where, as Mr. Solonka has mentioned, look at the Ndungu report. We also have searches at the registry, company registry. It's always good to undertake whether the persons have any encumbrances, whether even those directors are adjunct, are bankrupt. And then also, of course, you could do a quick run in court and even the land registry to just establish the status of that title. The second one, of course, is inquiries. This is where you then visit the land. You saw last week the president saying that there are some people who are holding title deeds on runways and roundabouts. This is quite critical that indeed you visit the actual land based on the maps and the mutations that you could be in possession with, just to confirm that. And the last one, of course, is requisitions. And this is where then you inquire about just the title, engaging the vendor, trying to also understand the dynamics of how the title is, and that is tied actually with the first one, which is the searches that you might have. So you're basically engaging the vendor on the outcome of those searches. In terms of commercial law, mostly due diligence will come up when you're doing either things to do with mergers and acquisitions, and even franchises for that matter. So basically it's a courtship process, and you'll want to find out exactly what the status of the other company is, and this could be in form of what is their balance sheet, how are they looking like, do they have any liabilities that are beyond their assets, are they, as Mr. Alex had mentioned, the issues of balance sheet insolvency and even cash flow insolvencies, those things will come up. Do we have, who are the decision makers in a company? You could find somebody like Moria is the CEO of Centum, but then you realize that the big man behind it was actually indeed Chris Kerubi and many more of those. So you want to establish the governance structures. And of course, what is the competition in the market? You say that you'll find some companies, let's say Safaricom is a dominant player in the telcos industry, but then you could be having some new entries who might challenge that position. And then also the other issue, which is quite critical, is the regulatory requirements. And you saw even in the case of where Nakumat Tuskys tried to merge with Nakumat, and of course that one was rejected. We've also had various venture capitalists, like now the No Fund. This is the Norwegian sovereign fund, which was trying to acquire some of Kenyan companies, and indeed the same was rejected. So that regulatory framework, and this one you're looking at CMA, you're looking at Competition Authority, you're looking at Capital Markets Authority, as I've mentioned, looking at even the Financial Central Bank and many more of those regulatory agencies. So I'll say that by and large is the scope of due diligence in commercial law and also conveyancing. Thank you.
Great. You've talked about two searches. So if you had a client, which search would you go for and why?
In conveyancing, just come again.
Yes, in conveyancing, you've talked about the official search and the personal search. So if you had a client, I'm interested to know which search you'd opt for and why.
The first and most critical search, of course, is the official search at the land registry, just to establish the validity or the bankability of that title. And then, and this is quite critical because you see also that search reveals encumbrances, cautions, and prohibitions that might be on that piece of land. And also, it will also give you some level of historical progress of that land. I mean, who was the previous owner, who is the genuine title holder, and many more of those. And I'll just give you a very quick, simple example. Like recently, we saw that this owner of Princess, it's called Princess Hotel, who went and acquired a loan from Equity Cooperative Bank and even KCB, and none of them was able to undertake a search to establish that indeed somebody else had already charged those properties. So that will reveal to you that kind of search. But then the second search, of course, which is quite critical, and the courts have been very brutal on this one, is the issue of historical searches. You want to establish whether the land is a public land or was in the Ndungu report, and many more others. You can remember now the situation that we are in with the Weston Hotel, where their KCAA is trying to recollect, or rather to retake back the piece of land. We have a loan of 1.5 billion from KCB, who is trying to tell the court that indeed they have invested in their money. So all those things can be avoided if indeed such searches are undertaken. Thank you. So I'll advise my client to do first an official search, and then the second one is the historical search, just to give comfort that indeed the land is not among those that are mentioned, like in the Nung report and in the public land. Thank you.
Okay. What's the timeline for conducting requisitions?
Very well. So the requisitions are quite. You see, also the I would say the completion period has to be undertaken within a certain time frame. That if you look at the LSK condition of 2015, mostly has given 90 days. So the assumption I'll go with is that that is the tenure that you may want to undertake the requisition, so that then you are able to do a completion of that transaction. But as I also revert with sufficient details, I believe that is what will suffice for now. Thank you.
Okay. Talk to us about injunctions and their applicability in cases when it comes to the national government and county governments.
Thank you very much. So injunctions are mostly provided for in Order 40 of the Civil Procedure Rules, and also Order 39 on the Civil Procedure Rules, which then now provide for things like Mareva injunction, and then of course Order 40 now then addresses issues of injunction, interim injunction, prohibitory, mandatory injunctions, and many more of those nature. So now when it comes to government, we have this act called the Government Proceedings Act, I think of 2012, which then now also has to be read together with the civil procedure rules. And the courts have been kind to guide that indeed when it comes to government organs, and that is both at the national and the county level, is that you cannot issue orders ex parte against the government. So you must first serve the government, and the government has to be invited to then be able to file in their response, and thereafter is when such an injunction can be issued. And I think also Order 29 also tends to have relevance in as far as any of those proceedings or judgments or orders that the court might be giving. And of course, that also means that for you to make any movement against the government, you must then seek the leave of court. Thank you.
Awesome. So I've come to the end of my questions. I'll give you feedback after the other panelist.
Thank you so much.
Lavins.
Right, thank you. Edie, how are you?
I'm okay, Mr. Lavins. It's good to hear your voice again.
Good to see you. I mean, good to see you. Been a while.
Yeah, I must admit that indeed, if law fails, please try and get a career in radio. It will still serve you and you'll earn your keep.
Oh my goodness, you've bribed the panel member, so I don't know. It's a red flag, Well, so back to business. Okay. So we begin.
Sure.
Right. So what is the relationship between criminal law and probate? Just two.
Very well, thank you very much. And allow me to take you to section 45 on intermeddling. And this is quite an interesting provision, because then the law requires that somebody has to be have authority of either the testator or the court in as far as matters of the estate is concerned. And this one, the testator comes in through either as a will, where you appoint an executor. Then in that such a case, then an executor does not need interim orders like ad colligenda and many of those interim. You just simply move, and then as he waits for confirmation of the grant. But the intestate, then you need to move with letters of administration, which then you'll be given maybe probably interim or interim grants. Then you can be able to collect and preserve the estate. The second one is under section 96, which is on forfeiture. And this is quite novel, because if you remember the case of Riggs v. Palmer, which was quite a classicus in as far as matters of forfeiture are concerned, where you had a grandkid who discovered that indeed he was the beneficiary of the will. So he moved to kill the grandfather. And of course, what this law then says that you cannot benefit from from having killed your, the testator in this case. So I'll say those two really creates a good nexus between issues to do with probate and also criminal law. Thank you.
All right. Thank you. So when there is a war, what happens to a contract? When there is a war, what happens to a contract?
Very well. Most people will run quickly to force majeure as a provision, but then I must also be quick to dissuade, or rather resist the invitation to hang around force majeure, because war must be in a state that then frustrates the contract. Because we have, say, for example, a war that maybe is affecting a town like, say, Mombasa, and your supplier, or rather somebody who is supposed to do a contract, is in Nairobi, and you're supposed to be fulfilling a contract in Kitale. Those two might not have any correlation. So you must have a situation of a war that then affects the operation, or rather the fulfillment of that contract, for it to be frustrated. Thank you.
All right. My third question, what do you understand by the term corporate personality? What do you understand by the term corporate personality?
Very well. And indeed, allow me to seek refuge in Section 5 of the Companies Act, which then now provides the ability, actually even Section 2, which then now creates companies as legal separate entities, which then are able to have their own, personality, which can sue and then be sued in that manner. And this, of course, the locus classicus is in Solomon v. Solomon, and then of course many more other cases that came there about where a person separate from their own legal entity, then which can be sued and sue in their own name.
Right. Briefly describe the procedure of conversion of a business to a company. Briefly describe the procedure of conversion of a business to a company.
Very well, and indeed, it's always said that when it comes to matters of conversion, it's always a one-way street. You cannot say, for example, convert from a company to a business. But now, be that as it may, it's good to indicate that indeed a business name is where somebody is running as a corporate sole, or not really a corporate sole, but somebody running as a business name where they don't have their own separate legal entity, but they bear liability. So somebody may want to convert that into a company, and the conversion, of course, must be, you must fill the relevant form. In this case, I may have to confirm, but it could be CR1, which then now you then make the necessary applications by attaching, because you see, being a sole proprietorship, you don't need much of resolutions and many more of those. But where there are more than one person, then indeed you may have to have some level of agreement or minutes or record of that resolution to then move to a company. And here you have to choose whether it's a limited liability company or any of private company, I think that was not clear, but then you must indicate any of those, but you must meet the requirements of registration as a company, and that one you must give articles of association, memorandum of the articles of association and memorandums, and then of course the statement of nominal capital. You pay the requisite fees as they are required, but then before that you must have also reserved the name for 30 days, where the registrar will then allow you to move by filing now these other relevant requirements, and you attach IDs, copies of IDs and passports, and even the names and addresses of directors for those companies. Thank you.
Right, my fourth and second last question. What are the documents essential before trading for a public company? What are the documents essential before trading for a public company?
Sorry, just come again. I missed that.
What are the documents essential before trading for a public company? Did you hear me?
Yes. Actually, it's quite clear. I was just taking a breath as I try to digest the question.
Okay, I'll proceed.
Yes. So I'm trying to imagine that this is where you are registering a public company, just for clarity purposes. Could that be the question, or trading?
Just trading for a public company. So
Very well.
I just really want to give you perhaps the cues and the pointers. So just limit yourself to trading for a public company.
Thank you very much, Mr. Lavins. Of course, we assume that indeed this is a company that has at least a minimum of 50 subscribers. In this case, they have, of course, shares that have been held publicly. And one of the things that then will allow them to have is for those companies that, a public company must have also a company secretary, which is also one of the requirements in the Company Act. Irrespective of how much their nominal capital is. For private company, remember, you have to have minimum of 5 million nominal capital, but for public company, you must have corporation or company secretary for that matter. And then, of course, they are at liberty to invite and trade publicly for the shares that are currently they hold. And then, of course, they must file the necessary statutory requirements with the registrar of companies. So I would say this one I'm a bit thin, but I'll just give that will be the basis for my answer on the issues of trading in a public company. Thank you.
Right. My last question will be, what do you understand by the term contracts uberimai fidei? What do you understand by the term the contracts of uberimai fidei?
Contracts uberimai fidei is quite an age-old expectation of contracts, and are mostly found in the insurance sector, where you have a situation where the person has to disclose or give contracts in good faith, where there's some certain disclosures that are expected within for somebody to make, so that then as you enter into contract, the persons believe that indeed the information have been given in good faith and without any material inhibitants or alterations. And I must give you a very interesting case the other day, when I came across a colleague who hid some information about the existing conditions. And of course, I told the person that indeed the insurance has every right to rescind on their contract. In fact, they can pocket the premiums and still charge you, or rather take any cause of action against yourself, because such principle exists in law that indeed it must be in good faith. Thank you.
And perhaps just a follow-up question, just a thin one. You have mentioned insurance contracts forming part of contracts uberimai fidei. Perhaps what other type of contracts or agreements could also, form part of contracts uberimai fidei, aside from insurance contracts? Which are these other type of agreements or contracts that perhaps could be, could meet the essentials of contracts uberimai fidei?
Very well, thank you very much. And this one, this concept is applicable virtually in all commercial contracts, be it in matters of land transactions, be it in sale of goods, where you have the Sale of Goods Act, which then now gives both the conditions and the warranties that have been listed from, I think, section 12 actually, all the way to about 17 and 18. So I would say practically all these contracts, even in terms of charges, movable properties, and many more of those contracts, each of those contracts expects in one way or the other, in one aspect, to have disclosure material, latent material disclosure, patent and latent material disclosure of some of the underlying facts that might affect the substratum of the contract. Thank you.
Thank you. Fair enough. Back to you, Evelyn, for you perhaps to give your feedback, and then I'll come in later. Thank you.
Mr. Indy.
Yes, yes.
I'm really, 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 really impressed by how you answered questions. And first of all, thank you for appreciating our presence with Sumaya. That was such a nice conversation starter. Number two, you answered the questions impeccably. And okay, let me tell you something. You see, you're a great conversationalist, and it works for you. So in relation to my second question, principles of data protection, you didn't answer in form of a list, but when you gave me the story and the background of the case, I could lift the principles myself. And that is a good thing. So instead of you passing on the question, at least you gave the background of the case. And as much as you didn't answer my question directly, I could lift a number of principles from the story, and that worked in your favor. All the other questions you answered appropriately. Okay, so in terms of the search, I wanted you to mention about indemnity, but you answered really well. And then in terms of the timeline for requisitions, yes, there is the LSK conditions, and it's broad, listing 90 days to finish up on the contract and everything. But we also have a provision. I'll share it with Pareno, the specific one, that lists out 14 days after signing the contract. So you can take note of that. And then in terms of injunctions, so there's a difference. When the civil procedure rules talk about the national government being exempted from applicability of injunctions, right?
Mm-hmm.
Yeah, but the same does not apply to county governments. There are two cases I will share with Pareno. So there's one involving Nairobi County and Cooperative Bank. So Nairobi County was claiming that since it's part of government, they're supposed to be exempt from injunctions. But then the court said, you know what, no niggas, you people are the county government, you're not the national government. And if you were to be exempt, first of all, Parliament would have passed that amendment, either by stating it in the civil procedure rules, because the Constitution was passed in 2010, and so were the civil procedure rules, right? So that would have been stated either in the rules or in the amendment to this act, something Government Relations Act. It would have been stated either in Section 12 or Section 16, but it has not been explicitly stated. So you are not exempt. And then a few years later, Trans Nzoia County went to court with the same argument, and the court was like, we've been through this thing. You people are not exempt. So you can take note of that. I'll send Pareno the full citations, but I am very, very much impressed with how you answered your questions. Already you've picked up marks on your dressing. That's why I asked you the first question. Those are free marks. So you've dressed well, you've answered the questions well, you know the law, you know how to apply it, and you know how to respond to questions, and you know how to make the panelists love you. So thank you so much. Oh, and thank you for my handsome boyfriend. At least he's handsome.
Yeah.
Thank you. So you have a great night, and Congratulations for showing up and showing out.
Very much. Thank you. I appreciate.
Amazing. Thank you, Evelyn, for that poetic parting shot. So back to you, Indy. Where do I start? You bribed me already. You know, sometimes bribery doesn't equate to, you know, monetary value. So your opening statement, you know, your compliment sort of breaks the ice. I don't know, maybe I'll consider a career in radio, cuts your view, but that's one way, you know, sometimes when you perhaps get yourself to that room, you know, where the panel members are, sometimes what you need is the icebreaker. So the first thing that comes from you will either determine how the progress or how the flow of the entire, you know, oral exams will be, or it will impede, okay, perhaps the progress of the same. So I think for me, even the questions that I had, as complex as they were, perhaps I set them aside because of what you told me from the beginning. So yeah, so a career in radio, I'll think about it. But thank you for your kind words. So back to the questions. You have a way with one. You perhaps understand exactly, you know, what you're asked. You take time to digest the same. I don't know, you know, I always try and avoid perhaps asking you questions, not because I don't want to, but because you'll perhaps give me more than I asked for. So for me, that only means one thing. Perhaps the way you read, you know, you read extensively and you read intensively. So come what may, I think you're one of those people I expect to do highly to achieve, you know, the best, perhaps not only in oral exams, but in the bar exams. And this I'm saying from not from a point of flattery, not from a point of favoritism, but from a point of conviction, because I've seen your growth, okay? So each and every time I keep tabs of exactly how you perform together with other students herein. So I'll compare notes, you know, when that time comes and tick, say you perhaps met my expectations, and that's the best I'll ever perhaps ask from you. And it will be a pleasure, you know, to the rest of us, knowing that you guys, you know, did well, and it was quite substantive for us to pour our hearts, our souls, you know, our energy, our knowledge, and everything, to just make things work out for all of you. So now, just giving you the feedback on perhaps the question I asked you, I'll start with the contracts of Uberi Maifide. Yes, you understand what this meant, and your mode of presentation also backed up, you know, your experience in terms of perhaps knowledge about this. So the only thing perhaps I'd say, there are, aside from commercial contracts, perhaps what I needed you to do is to tell me examples of these commercial contracts. And you mentioned, you know, the sale of land. You also mentioned insurance contracts. So there are also, you know, partnership agreements. You have contracts of guarantee and even prospectus. Perhaps if you added this to your list, you would be complete. But thank you for, you know, answering that one right. The other question that I asked you was about, was about if I could remember right,
the public company trading.
Sorry?
Trading on the public company.
Oh yeah, before that, I asked you about whenever there is a war, what happens to a contract? Yeah, you perhaps you did answer that right. The parties sometimes would plead, you know, force majeure, but in most cases, you know, these contracts will be terminated by, you know, even frustration. And where the contract, you know, perhaps involves a party from an enemy country, you know, it does become illegal. Yeah. So yeah, now to the question that you asked, the documents essential before trading for a public company. Yeah, at least you tried, answering this, but the answers I needed: one, you have the prospectus; two, you have the contracts themselves, which I think you touched on slightly. There's also consents, and lastly, we have the financial records of the company. And then the question that I asked you was about procedure for conversion of a business to a company. Okay, perhaps you maybe had an oversight of the form that I needed. I think you mentioned C or something. Yeah, but you tried. You at least you had an idea of what you are talking about. So when it comes to conversion of business to company, and thank you for giving me that background. At least you understood exactly what it means to be a business. Okay, so the transaction requires that a notice of cessation, which is normally Form BN6, be prepared with the advocates and presented at the Register of Companies, and then this particular document notifies the registrar that the owners of a particular business wish to stop using a particular business name. So the notice of cessation, will be presented together with the original certificate of registration of the partnership. And then now, once the notice of cessation, has been approved by the Registrar of Companies, the advocates, should reserve the name that the clients wish to use for the company, they intend to incorporate. Because now this is always done through a letter to the registrar, requesting MOHAD to just conduct as such, confirming that no company with that name does exist. And if it does so, to reserve, if it doesn't exist, that name has to be reserved. So just to add this on what you said will again make your answers as complete as possible. Then the last question that I asked you is about, no, the second last, I think. What is corporate personality? Yeah, you got that one right. So corporate personality, encompasses, the capacity of a corporation to have a name of its own. So to sue and be sued, and to have the right to purchase, sell, lease, and mortgage its property in its own name. And then in addition, property cannot be taken away from a corporation without the due process of the law. Now, the last question that I asked you, the relationship between criminal law and probate. Fantastic. You did well. You expounded on that, quite profoundly. I wanted to listen to you talk more about it because, you captured my attention to ask that. So I was there listening. So it was like a book that I didn't want to end. So you got that right. There's intermeddling. You also have perhaps someone who wants to benefit directly from the estate of the deceased, murdering the deceased so that they could, benefit from that particular estate. So there's a principle that, perhaps you can't benefit from an illegality. Okay. Yeah. So that one you did fantastic well. And as a cap up, you were great. You're fantastic. You'll do well. At least if you don't believe in yourself, I do believe in you. So you go there, do your thing. You are prepared, and I hope you are on the first day of the oral exams. Honestly,
I am on the first day, Mr. Lavins.
amazing instincts. Wow, that's great. You'll do well. I do believe. So give your best, do what you can, and just have fun. By the way, have fun answering the questions, but limit yourself to the time given so that you end up not missing perhaps the important things that you are supposed to mention. So all the best, Kila Lahiri.
Thank you so much, Mr. Lavins.
You're welcome. So back to you in studio, Solonka. I don't know if you're on radio or on TV. I don't know. Yeah. But take over the mantle.
I have really enjoyed this session. I really enjoyed it. Edie, you bribe Lavins. It was a really enjoyable session. Props to you. So yeah, you answered my questions very well. You got all of it right, all of them right. The debenture document is basically a security arrangement. or a security instrument that is entered into by a creditor and a debtor to secure the interest of a creditor. It can be in the form of a fixed charge or a floating charge. The other one was a requirement for a valid lease, in writing, needs to have defined premises, and it also needs to clearly show the time for the lease. The principles, you can get them from the case of Street versus Mountford. So, defined premises, a defined time, and so forth. And the other one on the question on prosecutor, where you find that a charge is defective, you answered it actually very correctly. The only thing was the statutory provision, which is found under the CPC under section 214. So the recourse for that is simple. You can either amend the charge, you can substitute, you can withdraw, as you rightly pointed out. But you need to take heed of the stage in which that matter has reached. It has to be before the close of the prosecution case, and the statutory provision for the same is under section 214 of the Criminal Procedure Code. And I think that's just generally it. So yeah, that's it. You did very well. The only bit was on requirements for a lease. There are three main areas. It has to be in writing, exclusive possession, defined areas, and for a definite time, for a fixed time. And that's all. And what else? Now, away from that, the way you introduce yourself, now, something that your colleagues can learn from the interaction between ED and Lavins was the rapport they created even before Lavins began asking him questions. That's very key. I remember when I was doing my orals, when I walked into that room, I did not wait for the panelists to begin, but I just walked in and immediately I said, good afternoon, Ms. Kigwada. Good afternoon, Mr. Oriri. And they were surprised and they asked, you know us. Then after that, they introduced them. They didn't even introduce themselves. They asked me, from which class are you from? I told them, I'm from class C. Then the next question was, how do you know us, yet I don't teach you? Ms. Kigwada didn't teach me, and Mr. Oriri didn't teach me. And I went on ahead. And I talked about Ms. Kigwada because I had done some due diligence about her because I knew I was going before her. And the person who actually helped me with the due diligence was Alex. We were very close with Alex. So Alex told me, Kigwada she used to teach Kenyatta University. She practices conveyancing a lot. So I gave that brief introduction. You are a conveyancing lecturer. You taught Kenyatta University School of Law. I am an alumni of that school. And then after that, I went to Mr. Oriri and I said, Mr. Oriri, you're doing a very good job at the Advocates Benevolent Association. They laughed. The panel, both of them laughed. And trust me, I had an easy time even when we were engaging with the oral questions. It was more of a discussion rather than a question answer moment. We were discussing. That's what got me good marks. So you can learn from that introductory bit between ED and Lavins. You need to take note of that because it's really crucial, creating a rapport even before the orals begin. And just to close it up, Cheruto brought out a Court of Appeal case. Now, Cheruto, I've read the 2018 case, and I note that, let me just open it. And I note that from the case, they did do away with Section 6. They actually affirmed the principles in Section 6 of the Land Control Act and held, and affirmed that indeed the requirement for you to get, like it's mandatory for you to get the Land Control Board consent. Seems like I've lost the case. It's a requirement for you to get the Land Control Board consent within 6 months after entering into a contract for sale of land. They affirmed that principle. But at the same time, they held that equity will step in to prevent unjust enrichment. Now, the affirmation is found under, you can read paragraph 22. I noted it down before the case closed. Under paragraph 22, they clearly held that, you see, a contract of sale is not void from the beginning, yes? But if you fail to obtain the consent of the Land Control Board, it becomes void at that stage. Yeah, it becomes void. That is the principle. It's void. However, the courts can step in to prevent unjust enrichment. And in this particular case, the facts were that there were some people who bought a piece of piece of property, and after buying the piece of property, the vendor alitaka kuaruka. And when they went to the High Court held and granted an order of specific performance, meaning that the vendor had to transfer that piece of property. The vendor wanted to rely on the defense that, this contract is void, it's unenforceable, so they have no right to bring it to court. The High Court granted an order of specific performance. They appealed to the Court of Appeal, and the Court of Appeal affirmed the decision of the High Court. They didn't do away with Section 6. They just held that the courts will step in as a matter of equity. And that's why they brought out Article 10 of the Constitution and various other case laws in that matter. So that's the clarification. They didn't do away with Section 6. They're with Section 6. The position is still as it is, that failure to obtain the consent of the land control board will render the transaction void. However, the courts can step in as a matter of equity, and it depends. They use this word, it depends, on a case-by-case basis. That was the reasoning. So I hope I've cleared that up. Karen?
Yes, thank you.
Okay, that's fine. And then Sumaya had some comments. I don't know if she's asleep or she's still in. Sumaya.
Hi, Solonka. I'm still in. Why would I sleep this early?
Okay, go ahead.
Yes, exactly. Sherehe lazima. So, hi Edie. I know you're on the first day for your oral panels. For your oral panel, I just wanted to give a few comments on how you answered the questions. Sure. So, first of all, Kizungu leo inakataa. I don't know why, but anyway. So the first comment is when you asked the question about Huduma number. I noticed that you told the panelists that there are two cases. I'd like to know, or maybe a clarification or to answer. So personally, my strategy for my oral exam, which eventually worked, but it depends. People are different. My strategy was to answer the least possible questions by making sure I maximize on how I answer the questions, right? So if you're given that golden opportunity, mind you, you know both the cases, right? Don't short style yourself. Tell them, first of all, there were two different cases. One was by the Nubian Human Rights Group. The first one spoke about ABCD. The second one spoke about, CDE, etc. Maximize on what you know. Since you know both cases, make sure that you take at least, even if you can, 3 minutes on that question, right? So personally, I think the best move would be to talk about both of them so that the panelists also know that you understand both cases, you know both the different issues the cases brought up, and that you're confident in your understanding of both the cases. Hi, number two. Wonderful. Yeah, number two, I feel like your speed is kidogo fast. And this is something I also personally struggled with a lot because I speak really fast. So I remember just before, I think a weekend before I was also in week 1, but I was week 1 Friday. The weekend just before our oral exam, we had like a mock session, and everyone kept on telling me that I speak fast, which is true. I'm actually really trying right now. But the one thing that stuck with me was that I was told that if you speak really fast, people assume two things. They assume, number one, either that you don't know a lot, and so you're speaking fast to cover the fact that you don't have content, or that you're speaking very fast because you have a lot of content. Most of the time, people who speak... Sorry? Is someone speaking?
No, go on.
Okay, so most of the time, people who speak fast, scientifically, it means that our brain works very fast. Like people who speak fast are generally, smart, because your brain is overworking, and so your mouth is trying to really catch up with that, right? But then on that day, you have to be extra, like try to be a bit slow, try to pause, Sawa. So personally, I feel like content-wise, you're A1. You can even unaweza funga vitabu hadi siku ya orals and you'll be okay. But just your speed it's not as fast as I speak, at least uko sawa. Punguza tu kidogo, try to make some pauses in your sentences. It will make the panelist get more attention on what you're trying to say. And then number 3, on the question the question that you asked about war. Okay, so we know that the panelists, are lawyers and the advocates of the High Court, and that they understand legal things, right? But try to have a build up in your answers. I noticed in all the answers, you do this thing that's called quote unquote attacking the answer. I don't know how to say it, but you go straight to the answer. Some panelists love that, and that's why, again, which is the most important thing I'll tell you guys today, is make sure you read the room once you enter the panel, once you enter your session. Why is that important? If you're able to read the room, you can know the panelists are friendly. You can give them compliments the way you give compliments to the panelists. That's very nice. Break the ice where you can break the ice. Where you feel like the panelists are a bit hostile, they're like this. Sometimes you see how you practice and say, like, when you ask a question, you can say, number 1, this is how I'm going to answer the question. I'll answer it in 3 phases. I'll give phase A, phase B, phase C. Some panelists are very impatient. They'll tell you, okay, tell me 3 scenarios where you use a petition. Number 1, number 2, they'll actually guide you like that. So the most important thing is reading the room. However, given a scenario that you've been asked a question like the one you're asked by Patrick, make sure give some sort of background on your answer, right? Yeah. So start by saying an act of war falls under this type of contract, and then don't assume that the panelists know what frustration is. Go ahead and now differentiate. You understand? Then say frustration, and then this is again, I think there's something we've spoken about, Kitambo. There's this skill where you lead the panelists to asking you things which you know. That would have been the perfect scenario for you to say that. And a good example of frustration is what was seen when the COVID-19 pandemic hit, and it affected many contracts. You see, that was the perfect time to bring something like that, right? So differentiate. First of all, start by differentiating. We know the answer is not frustration, but start by saying what frustration is and why this answer in this scenario differs from frustration. Don't assume that the panelists know frustration, although you think they know. So try to keep try to be very relatable, try to be very simple, because you might find out, which is a very sad thing, you might find out that the question you've been asked by one panelist, the other panelist doesn't have a bit of background information on it. And so your background information, number 1, shows that you understand the law better and that you're a good lawyer, but also number 2, helps them to keep up with your answer. So I think those are the main 3 things I noticed. Just a bit on your speed yako kidogo to just kidogo. Don't stress so much about it, but do that. And then there's a question that was asked on something on injunctions. There's something you said. You said injunctions are mainly entailed in Order 52 of the Civil Procedure Rules. Remove that word mainly. And the reason why I'm telling you is because, of course, they are in Order 52, right? Is it 52 or Order 49?
Order 40.
Order 40, correct. Sorry, Order 62 is not so motions. Sorry. So yeah, make sure if you don't know the exact provision, you can say in the Civil Procedure Rules. If you do not, say it is contained under this order. Don't use the word mainly. And the reason I'm telling you this is because I had a personal experience like that. So in my and that's the few questions, the ones you feel like, oh my god, I didn't do my best during orals because of ABCD. But there's a question I was asked by Mr. Moniki. He asked me, what is re-exam? And we all know that re-exam is the examination, the questioning that comes after cross-examination, right? So yes. What did I say? I said it's that examination that mainly, I use the same word, yes, I use the word mainly. I say that mainly comes after cross-examination. And the first thing, some panelists are very particular. That's why you need to be very particular in every single word you say. Moneki asked me, mainly, how he's very dramatic, right? He asked me, mainly, what do you mean mainly? Does that mean that sometimes it can come before cross-examination? And at that moment, I knew that I said the wrong thing, right? So I was like, oh, I'm sorry. I would like to correct myself. Re-examination does come. It's that form of examination that comes after that form of examination that comes after cross-examination. So be very particular in the words you use. If you're not sure, you can say that, covered by this, or you can say general mainly, but if you're sure that it is under this provision of the law, then quote the provision as it is. Don't leave words, don't use ambiguous words where you don't, because sometimes it depends on who's listening to you. Some panelists are very specific in the kind of words used, which now goes back to your speed, right? If you try to control your speed, then you're aware of every single word that's coming out of your mouth. So no. Yeah.
Sure.
But other than that, that's a really nice presentation. I liked how, again, you built a rapport with the panelists. Do that. Again, I know that I don't know, I mentioned this before, but I'm not sure if you guys, implemented this. But I know now the oral schedule is out. Please start forming those WhatsApp groups. So I noticed there's a big contrast. The year before us, the guys were in KSL 2019. Most of them were being told their panel when they're in the waiting room. They're being told, panel 1, you'll appear before, Mr. So-and-so. Panel 2, you'll appear before Miss So-and-so. They were being told. But for our year, we were not told. Again, you see how Solonka said the fact that he knew the panel, he was able to strike a conversation with them, right? So personally, me, I didn't strike a conversation with any of them. But they asked me, they were like, do you know any of us? And I was like, yeah, I know Mr. Moniki, you're my child advocacy, lecturer in class C. And the other one was Mr. Kimela. I said, Mr. Kimela, you're legal practice LPM lecturer, but I've not, I've sadly not been able to interact with you, in class. So they didn't give me that space to, go ahead. But I had, I had read on their achievements and everything. And the only reason I was able to do that is because I was number 4 in my panel. I wasn't number 1. So please, guys, form those groups. You can use the KSL 9Ps gang, the groups you used. You can use those groups to share the dates. So just create a group that has, for example, you can say, I don't know when you guys are starting exams, but you can say Monday, date this and this. Afternoon, panel 1 or panel 2 or panel 3. You can say things like that. Just open the group. And if you're number 1 on the panel, please help people. Like, it will literally take nothing away from you. When you leave the exam, just text the panel. Because if people are told, it's fine. If they're not told, let's tell people. It really helps people. Because at the end of the day, oral kind of does make a significant difference in your grades, right? We all want to get good oral marks. And you not knowing can definitely help, but you also knowing can always be an advantage, right? So open those groups. Immediately you leave the oral, even if you're number 2, number 3, once you leave that exam, drop the text to the group. Just tell people, I have this panel, there's, lecturer this and this, and I was asked the following questions. Tell them, because sometimes even the questions are repeated. Sawa, and we all want to pass. And remember, when it comes to oral exams, like don't feel like, kwani mimi niko number 1, why should I tell people what I was asked? No. Immediately you leave the room, you're graded. You're graded immediately you leave the room. So even if number 5 or number 10 in the panelist is spectacular and they've wowed them, kama ulikuwa number 1 day 1 and you did really good, you'll still get your 18 or your 19 or your 17 or your 15. You'll still get good marks because immediately you leave the room, you're graded. That's why you'll notice when people leave at, like, if number 1 leaves the panel, number 2 doesn't enter immediately. You see, number 2, it takes a few seconds hivi, utaka nje, upatiwe sanitizer, or sign form flani. It's like a procedure you'll do. So you don't enter the room immediately. That means you're graded on the spot. So once you leave the room, your grade is written, imeisha, maisha inaendelea. So please help people. That's what I'll tell you. Open those groups. Once you leave the room, and this is a hack people usually do in KSL. I hope it doesn't, become public hadi watu wa KSL wajue tunafanyanga hizi maneno. But that's a good hack. Open the group, share with the people. Saidia watu. Honestly, being a good person goes a long way. At the end of the day, this is, the legal career. It's a very small career. All the networks you form here will help. You might probably not gain anything by telling people the panel, but through your kind words, you can be repaid in another way. So open those groups, share those details, and study the trends. If you're appearing anytime from day 2, day 3, day 4, or even week 2, study the trends, get to know what questions are asked, collect all those questions from the WhatsApp group, revise them. Do simulations with your friends. I hope you guys are doing private. This is not enough, by the way. I hope you guys are doing your private discussions. In those private discussions, some colleagues can can act like panelist, ask questions, give feedback, improve yourself. The more you do these simulations, the easier it becomes for you to do it at the end of the day. Also, I think I'll just close by saying orals is literally a 10 mark thing. A 20 mark thing, which lasts for only 10 minutes. Those 10 minutes will be the fastest 10 minutes in your life. So don't overstress it so much. As you said, unakosa usingizi, haulali, you're not eating because of exam. No, take a breather, sleep a lot, revise, do what you can. At the end of the day, you have no control what will happen in that room. So for now, give it your best. After the oral exams, imeisha. You move on with life, don't look back. So just move on and focus on what you can work on, which will now be the main exam. That's all I think I would say for now. Okay, bye.
Thank you for that. Yeah, I think it's already 11. It's past 11. We can close the session from there. So appreciate you coming. Then see you guys next week, unless there's anyone who has something to add. So you can see you guys tomorrow. Not tomorrow, over the next week, over the weekend. Bye bye.
Thank you so much. Thank you.